by now, so I can see folks at the top of my screen. So what I am going to do is, if I could, I know Whitney and probably Mary are, especially Whitney, keeping up with who all is on here, because now that we have the PowerPoint there, it's hard for me to see everybody at the top. So I will start with the introductions. I am Dorothy Hairston Mitchell. I'm a district court judge here in Durham, North Carolina. Most of us know each other, but we do have quite a few new people that are joining us today. I think we do have some new public defenders, chief public defenders that are on with us, as well as we have a new commissioner. So I want us to go through and do introductions of everyone. So Whitney, can you help me? Are you in a place where you can help me out with who we have all on?
Is just start a roll of the commissioners for you?
Yes, if you could do that for me, please. Because I usually have everybody. So if we could too, just to help our new people out, if you are a commissioner, if you could change your name on your screen and put like C dash in your name so that folks will know that you are a commissioner. If you could just handle that for us in case they want to know, we'll do the introductions, but at least they'll have that running list in the list of participants as we're going through. Okay.
Change my name.
I'm sorry. Okay. So you should be able to go to your name and right click where your name is, go to participants, right click on your name, and then you can do edit display name. And then you can just put a C hyphen and then your name. And that'll help every
or you can go to your picture and there's the ... You click on that and it says more options and it'll say edit your name.
Yep, that's the other way. You can do that way too. We got options. Always good to have options. All right. So yes, Whitney, if you could go ahead and call us, because I can't see. Well, I can see a lot of folks now. But yes, if you could do that for me, because since I'm sure you probably have all.
Arthur Beeler. Come back. Brian Jones.
How are you? I'm Brian Jones, Burke County. Been a commissioner for a few years now and glad to be here. And it's nice to see everybody.
Good to see you too, Brian.
Say that again one more time. Something keeps muting the room.
Brian Cromwell.
Good morning, Brian Cromwell, Mecklenburg County, Parker. I'm with Parker Poe, and I've been a commissioner for a while now. Thank you.
Kate Fenhagen.
Good morning, Kate Fenhagen, Criminal Justice Resource Director here in Orange County, and also Commissioner for, I think this is the start of the second term.
Karen Franco.
Good morning, everyone. Karen Franco, Commissioner. I'm with the Holly West Pony Indian Tribe, and I am domestic violence and sexual assault, and I've been here for about 2 years.
Joseph Crosswhite.
Good morning, Joe Crosswhite. I'm a commissioner from Arlo County.
Marshall Ellis.
Morning, Marshall Ellis. I'm out of Chowan County and I've not been a commissioner for even a year yet, so still very new.
Sorry, say that one more time.
Miriam Thompson.
Good morning, Miriam Thompson. I'm from New Hanover County. I've been a commissioner for a couple of years now, and I'm enjoying it. And welcome to all the new people.
Staples Hughes.
Hi, I'm in Chatham County. I've been a commissioner for ever, and glad to be here.
Tanya Barber.
Morning, Tanya Barber from Wayne County. This is my second year as a commissioner, and I am still here.
Stacy Rubain is going to join us a little bit late. She should be here shortly. Dorothy, when she comes in, I'll try to remind you to introduce her.
Okay.
Art Beeler again. Art, have you joined us?
Yes, I've got problems with my computer, so I'm calling in on the phone. and looking at the video. So I'm here.
And then finally, I'm going to ask George Doyle, or I'm going to ask our chair to introduce George Doyle. George, are you here?
I'm here. I hope you can hear me.
All right, Mr. Doyle, welcome, sir. We're glad to have you. Mr. Doyle is is one of our latest and newest commissioner that has joined us on this commission. And Mr. Doyle, I'm gonna give a little bit of your bio, if that's okay with you, and then I'll give you an opportunity to give some words if you would like to as well, okay?
As long as you got the right information. Yes, ma'am.
Well, if you stop me if I don't, okay? So I have that Mr. Doyle is a Chapel Hill trial attorney with more than 30 years of experience in civil and criminal cases. He served as president of the former 15B Judicial District Bar, the Orange County Bar Association, Sharp End of Court, and the Board of North Carolina Legal Services. In 2006, Mr. Doyle was elected to a 3-year term on the Dispute Resolution Section Council of the North Carolina Bar Association. Also in 2006, Mr. Doyle was certified as a mediator in matters before the Clerk of Superior Court, and he is therefore one of the few mediators in North Carolina to be certified in all areas of mediation by the North Carolina Dispute Resolution Commission. He thereafter became chair of the Dispute Resolution section of the North Carolina Bar Association and later the Continuing Legal Education chair of the section. Attorney Doyle remains an active member of the NCBA, continuing to participate in various courses, seminars, and section activities. He's been on the court-appointed roster in Orange and Chatham County since he began practicing law. And I see a Chief Public Defender, Robertrina Baker Harrell, shaking her head. So I'm thinking you're giving us some good representation over there in Orange and Chatham County, and we appreciate that, sir. Is there anything more that you would like to say? And again, welcome to you.
Thank you so much. And it's an honor to be on this commission. I've been an indigent lawyer, as I call it, for over 40 years. And so I'm very interested in the pay structure that I know y'all are going to improve. And it's been an honor to try some cases with Rena Baker Harrell and our former public defender, Susan Seahorn, and our first public defender, Kirk Osborne. I love the public defenders. They're great lawyers. They help us private lawyers be better. So I'm honored to be here. I appreciate it very much. And I look forward to doing what I can to help the commission.
Yes, sir. We've heard nothing but great things about you. We look forward to you serving with us. Thank you, sir. And Whitney, do you have a list of other folks that we can call upon for introductions to? So how about we start with our IDS staff? And then I'll introduce the new public defenders and folks later.
As far as IDS staff goes, I would ask that anyone who's online go ahead and introduce themselves for you, Dorothy, and just popcorn it to the next person online, and then we'll do it in the room. So I'm going to call out Kevin.
And then call out the next folks. So starting with you, Whitney.
Kevin, you start.
Good morning, Kevin Boxberger, Regional Defender for IDS, and I do want to welcome Commissioner Doyle as well as the new Chief Public Defenders. Glad to be here.
I'm Shannon Simmons. I'm Accounts Payable Supervisor, and it's a pleasure to join you guys today.
Angela Henderson, Contracts Administrator with IDS. I'm glad to be here with you all today.
I'm Becky Whitaker. I'm the Defender Policy and Planning Attorney for IDS.
I'm Sarah Olson.
Sorry, I knew it was going to happen. Go ahead.
I'm Sarah Olson. I'm the Forensic Resource Counsel for IDS. Tucker?
Tucker Charnes, a Regional Defender for IDS.
Hey, I'm Will Childs. I am the Budget and Planning Director for IDS.
Carla Huff, Recruitment and Training Coordinator on an IOTA grant with IDS.
Oh, I see the can.
Is that all IDS staff online?
I'm Chad Boykin, Assistant General Counsel.
Whitney Fairbanks, General Counsel, Deputy Director.
Christopher Sadler, Research Director.
Aaron Gallagher, IDS Fiscal Officer.
Amanda Bunch, Communications Specialist.
Mary Pollard, Director.
Max Silva, Legal Assistant.
All right. So then, okay, who we have left? Let's go with our special counsel.
Morning, Chad Perry, Office of Special Counsel.
All right. Do we have any of our other attorneys?
I have to log into the meeting.
Judge Mitchell, it looks like we have a couple, Eric and Wendy.
Hey, I'm Eric Sagra. I'm the State Juvenile Defender.
Good morning. I'm Wendy Sotolongo with the Office of the Parent Defender.
Good morning. This is Glenn Girding. I'm the Appellate Defender.
All right, we got Beth Hopkins Thomas. We'll go to you next. I see her on here.
There we go. Good morning, Beth Hopkins Thomas at North Carolina Prisoner Legal Services.
Okay, so then let's go to starting with our, aside from our new chief public defenders, if I could have any other seasoned chief public defenders online, if I can have you introduce yourselves. I know I saw Wadrina Baker Harrell earlier. Yes, I called you seasoned.
Yeah, you did. Thank you. Wadrina Baker Harrell, Chief Public Defender for Orange and Chatham counties.
Jennifer Harjo for New Hanover County. Thank you for all the work that you do.
Oh, thank you.
Boone Baxton, Durham County Chief Public Defender.
Good morning.
Good morning.
Got any other?
Gibson, Chief Public Defender out of the 2nd Judicial District, Beaufort, Martin, Terrell Hyde, Washington.
I'm Beth Stang. I'm the public defender in Henderson, Transylvania, and Polk counties. We're newly numbered 42nd District. Morning.
Thomas, Chief Public Defender of Wake County.
Deontay, good morning.
Good morning, ma'am.
Anyone else? All right, so I'm going to go ahead. I know it's a little amended agenda right now, but I'm going to go ahead and handle this in the introduction section. We do, as you all know, have some new public defenders. And so we have 7 new offices that opened as of January, and then we have 1 more set to open in Johnston County. And so those 7 offices that have opened, yep, that's a great picture, cover 22 new counties. And we are super excited. And I just want to point out right here, aside from them looking really, really nice on this picture, this is a picture from the day that they, IDS had a 2-day onboarding at AOC earlier this month, which I heard was chock full of necessary information for new chiefs. And I heard that they had a really, really good time and they learned a lot at this 2-day session. And Mary and her staff has been really, really awesome in their support of our new chiefs. And I'm sure that they will continue to provide that great support as they have to all of our other public defender offices and chief public defenders and assistant public defenders. We are so blessed and excited to have the new PD offices to help us in our quest to provide quality representation to indigent clients. We all know that that is our mission, and we look forward to them helping us in this regard. And so I want to have the new chiefs introduced, and I will just say from here that the new chiefs in the counties that are covered are Randolph Lee, who's from Defender District 30, Union County, Jana D. Allison, Defender District 43, which is Cherokee, Clay, Graham, Haywood, Jackson, Macon, and Swain counties. Seth Johnson, Defender District 32, Alexander and Iredell counties. Tonza Ruffin from Defender District 7, Bertie, Northampton, Hertford, and Halifax counties. Jacob Ward, Defender District 15, Bladen, Brunswick, and Columbus counties. Nicoya, and if I mispronounce that, please forgive me, Ms. Dobson. Defender District 5, Duplin, Jones, and Sampson counties. Ricky Champion, Defender District 17, which is Alamance County, and then Johnson County, which we don't have I don't think we've gotten that appointment yet. That will be Defender District 13. So we want to hear from them individually, of course. And so if we can, hold on, I'm trying to keep up with my chat as well. So Becky, if you could, I'm gonna pass it off to you. I know I just gave all the names, but if you could take it from there.
Sure.
Give us
Thank you
a little
so
bit
much.
more on these offices opening. You are welcome, and thank you for your help with this.
We're so excited. This brings us to having all of our new offices appointed, with the exception, of course, of Johnston County, because they haven't quite come online yet. We're hoping and expecting to get that appointment in the next couple of months. So just a little bit more about these folks. I think what I'll do is I'll run through just a brief introduction of all of them. And then open the floor for those of them that are with us to say any remarks that they would like to. So I will start. I'm going to go in numerical order. As Judge Mitchell mentioned, Nicoya Dobson, District 5, Duplin, Sampson, Jones County, is a native of Duplin County. She graduated from NC State University undergrad and NC Central School of Law. She was a public defender in Boston prior to being called to return home to southeastern North Carolina. She had a goal to build a career of service around a diverse work experience, and so she worked as an assistant district attorney in Onslow County. She prosecuted everything from misdemeanor traffic to first-degree murder. And after serving there for 4 years, she became an assistant public defender in New Hanover County, working under our own Jennifer Harjo, who speaks very highly of Nicoya. As a public defender there, she took an active role in training defenders, and she displayed an aptitude for leadership within the office. She defended clients in district and superior court. Her focus was high-level felonies. She then called Felt to work within her own home community and opened a private practice in 2021. She worked across Duplin, Sampson, New Hanover, Pender, and Onslow counties, representing retained and appointed clients on high-level felonies and civil matters. And when she found out that the legislature had created this defender district in the area that she calls home, she felt called to serve. So welcome, Nicoya. We are absolutely thrilled to have you on board.
Good morning, everyone. I'm happy to be here. Thank you.
Thanks, Nicoya.
Welcome, Ms. Dobson.
Yes. And Nicoya also goes by Nikki, and she assures me that anybody can feel comfortable to call her Nicoya or Nikki. She will respond to both. All right, moving on to District 7, Tonza Ruffin. District 7, Bertie, Halifax, Hertford, and Northampton counties, is a native of Bertie County. She has a bachelor's degree in political science, minor in women's studies from East Carolina. She is a graduate of Georgia State University College of Law, and she began practicing in North Carolina in 2000. For the past 23 years, she has passionately advocated for the underserved, handling a diverse array of cases ranging from capital murder, major felonies, all the way down to misdemeanor offenses and minor traffic violations. Apart from her legal practice, Tonza has been a member of the faculty at the Felony Defender Trial School at the School of Government. She has also served on the board of directors for the Center for Death Penalty Litigation. And she is fervent about offering support to young individuals to prevent their involvement in the criminal justice system. She believes that education or its absence significantly influences the rate of youth engagement in criminal activities. So we are thrilled to have Tonza in that part of the state.
Good morning. Good morning.
Good morning.
I'm so happy to be here and be a part of this endeavor. I'm looking forward to working with all of you all. I'm not putting myself on video because I'm also on grandma duty this morning and I have my granddaughter in my arms. But thank you so much for that wonderful introduction.
Welcome, Ms. Ruffin.
All right, moving on to District 15, which is Bladen, Brunswick, and Columbus counties. We have Jacob Ward, who was born and raised in Whiteville. He has a bachelor's degree in criminal justice from UNC Wilmington, and he went to law school at NC Central, graduated in 2013. Jacob was a solo practitioner for about a year, focusing on criminal defense and juvenile abuse, neglect, and dependency cases. In 2015, he joined the 15th Prosecutorial District Attorney's Office, While he was in ADA, he prosecuted a variety of cases to include sex crimes, violent crimes, murders, and a capital murder. After being appointed chief ADA, he was responsible for nuisance abatement cases throughout the district. And some of you might remember this very interesting case down in his part of the state. He assisted in the removal of the elected sheriff of Columbus County. That was very newsworthy. And Jacob lives in Southport with his wife, Sarah, and their 2 children. Welcome, Jacob. We're glad to have you.
Thank you. Good morning, everybody. And I just want to say thank you to IDS. They have been fantastic while we're trying to set up these offices. There's 7 of us, and every time we call, text, email, we get an immediate response. So thank you to everyone at IDS.
Awesome. We expect nothing less from them. And from you all being great. So,
all right, moving west a little bit, we have District 17, which is Alamance County. Rick Champion is the appointed Chief Public Defender there. He grew up in Durham County. He spent his career protecting the constitutional rights of defendants, having more than 39 combined years of criminal legal experience on both the prosecution and defense sides of the law. Most recently, he was elected in 2020 as District Court Judge for Judicial District 15A, Seat 3. So Judge Champion is actually coming off the bench to take on this role as Chief Public Defender. Judge Champion has a bachelor's degree in criminal justice from UNC Chapel Hill and his JD from NC Central. We have lots of Central folks in these new positions. That's very exciting. Rick's legal career began in Durham with the law offices of John Borland. He began his career as an ADA in the 2nd Prosecutorial District in the 80s, transferred to the 15th Prosecutorial District. He then became a partner in Hemrick, Lambeth, and Champion, specializing in criminal defense and personal injury. As a prosecutor, he handled all kinds of criminal cases from capital murder to speeding. He was the primary child abuse and sexual assault prosecutor in Alamance County. He was the first attorney in the state to use DNA evidence in a felony case. In private practice, Rick became criminal law specialist and maintained that status until he returned to the DA's office in 2019. As a district court judge, he worked to ensure all parties in the courts were treated with respect and dignity, regardless of whether they had an attorney. He's an active volunteer in his community, really involved in lots of different areas of community service. And he lives in Burlington with his wife, Kelly. They have 4 adult children. Welcome, Rick. We're so happy to have you with us.
Thank you. A lot of that was still, advertisement, but I'm happy to be in this position, and thank you again for IDS for all the help we've gotten. Still interviewing for an investigator. So everything else is lined up. Taking cases already.
Awesome.
Ready to go.
Welcome, sir.
All right, moving on over to Union County, District 30. We have Randolph Lee. Randolph is a native of Charlotte. He did both his undergrad and law school at Wake Forest, and he also has an LLM from the George Washington University. Randolph was a captain in the U.S. Army and was awarded the Meritorious Service Medal. He has served as a special assistant U.S. attorney, counsel in the Office of the Chair for the National Labor Relations Board, counsel in the Office of the Vice Chair for the Interstate Commerce Commission, and has been in private practice since 1992. For the past several years, his practice has been focused primarily on criminal defense work, both federal and state, both retained and appointed. He was backed by a unanimous vote with the Union County Bar for his appointment, and he says he's looking forward to working with judges and prosecutors as everyone strives to meet their respective constituents' rights. And he lives in Wesley Chapel, a small community in Union County, with his wife. Welcome, Randolph.
Welcome, sir. Is he on?
He may not be with us this morning. So if anybody has the chance to see him out in the field, please introduce yourself and welcome him. Also moving on over just a little bit, and I'm not sure if Seth Johnson is with us this morning or not. Seth is the appointed public defender for District 32, Alexander and Iredell counties. He was born in Statesville, where he lives today. He attended Appalachian State for undergrad and another NC Central Law School grad. He has been licensed and practicing in the Statesville area since 2005, primarily in the area of criminal defense. Until recently, he was death penalty qualified counsel by the NC Capital Defender's Office, and he is very proud to have completed the National Criminal Defense College Trial Practice Institute, a truly transformative experience for criminal defense attorneys. His wife is an attorney. She's on faculty at Wake Forest University School of Law, and they have 2 daughters, ages 5 and 10. So welcome to Seth. We're very excited to have him on board as well. Like I said, I don't believe that Seth is with us this morning. So I will move on, last but certainly not least, to our last new public defender in a new district. Jana Allison is out in District 43. She has got a big responsibility on her hands. She's got 7 counties. I think the only other district with 7 counties is up in the complete opposite end of the state, the Northeast, District 1. So Jana is going to have Cherokee, Clay, Graham, Haywood, Jackson, Macon, and Swain counties. Jana was born and raised in Canton, North Carolina. She has an undergraduate degree in business and law from Western Carolina. And she has her law degree from Oklahoma City University School of Law. She's been practicing since 1999 and had a career as a paralegal prior to that. After law school, Jana practiced with Russell McLean for several months before starting her own practice, which consisted of court-appointed and retained criminal, DSS, child support, and juvenile delinquency cases. She became a board-certified specialist in state criminal law in 2006 and is on the Capitol roster. And she has been an assistant public defender in Buncombe County since 2010. So we have apologized to Sam out in Asheville for kind of poaching her to lead her own district, but he assures us that she is fantastic, and we've seen that as well. So welcome, Jana. We are very excited to have you on board.
Thank you, and I'm very excited too, and I just want to thank IDS for the training and support that I've received since this endeavor started. And I'm very happy to be here.
Welcome, Attorney Allison.
I do have one more new public defender to introduce to you all. She is not in a new district, but she is newly appointed. As you all recall, at our last meeting, we recognized John Neiman out in Greensboro upon his retirement. And so I want to introduce to you all his successor. Jennifer Ryerson is the new Chief Public Defender in District 24, which is Guilford County. She was born and raised in Greensboro. She has her undergraduate degree from Wake Forest and her JD from NC Central. We are just racking up those legal eagles. Prior to law school, Jennifer did some contract work on pretrial discovery for Womble, Carlisle, Sandridge, and Rice project. When she started practicing, she started taking on court-appointed work in her own law practice. She began with the Gaston County Public Defender's Office in 2006, and she joined the Guilford County Public Defender's Office in 2007. She became a public defender because she strongly believes that no one should ever be denied good legal representation because of their financial situation. As an assistant public defender in Guilford County, she represented clients in all types of cases from first-degree murder to drug possession, focusing primarily on clients with substance abuse and mental health issues. She was the driving force behind establishing the Guilford County Treatment Courts. Jennifer lives in Greensboro with her husband, Evan, who is an investigator with the Guilford County Public Defender's Office. They have 2 dogs. Welcome, Jennifer. We are very excited to have you with us.
Thank you. And I actually finished law school in 94 and started practicing in the Gaston County office in 96. I've never paid any attention to the fact that it says 2006, but
I think I got this information from John, so we can hold him responsible if any of it is incorrect. Thank you for the clarification.
Thank you.
All right. Well, he might have already been in full retirement and relaxation mode and had some things a little bit off. Let's see. Okay, so we have Stacy Rubain. I see you jumped on. If you could introduce ourselves, that rounds out our commissioners.
Good morning, everyone. I am Stacy Rebane. I am an assistant federal defender in Greensboro. Been on this commission for several years. Enjoy the work. Happy to meet everyone today and welcome to our new public defenders. We are very excited about having all of you on, and we are looking forward to the wonderful work that we're sure that you will do in your respective districts. So good to see everyone this morning.
All right, thank you, Stacy. And I know we have a lot of other guests that are, or a lot of other folks on here that are guests in our meeting today. And I want to welcome you all here as well, and anybody else that has come on and joined us since we began and went through all our introductions. Welcome to everyone. I now want to go ahead and jump into our meeting if we can. So I want to start first by reading the State Government Ethics Act reminder. Members of the commission are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this commission with respect to which there is a conflict of interest or appearance of conflict. All right, so if any commissioner has a conflict, if you could so note that now, or if when we get to that item on the agenda, if you could note it at that time. All right, next item on our agenda. Well, first, I need to go back. If I could have a motion to approve the proposed agenda with, of course, knowing we've kind of already gone a little bit out of order with our agenda. And I am going to also make another amendment to this agenda and have the staff report from Chad and Chris on the new invoice system to move up above the IDS, our director's report. So with that amendment, could I have a motion in regards to the agenda?
So moved, Dorothy.
All right, thank you. Do I have a second?
Second.
All right, got a motion and proper second to approve our amended agenda. All those in favor, please say aye.
Aye.
All right, any opposed, please say nay. All right. So next I will move to, I need a motion. All our commissioners, you receive a copy of the minutes from our October 2023 commission meeting, and you should have reviewed those. And if I could have a motion in regards to adoption of our minutes.
So moved. This is Bart.
All right. Thank you, Art. Do I have a second?
I second.
All right. Thank you, Stacy. All right. I have a motion and proper second to approve the minutes from our October 2023 commission meeting. All those in favor, please say aye.
Aye.
Raise your hand. I see you. Thank you, gentlemen. Anybody opposed, please say nay or give me a thumbs down. All right. Hearing none, those are approved. And so I'll move to the remarks, further remarks for me as the chair. Again, I would welcome everyone here to this meeting. I also want to say that as I stated before, that I really appreciate Mary and the staff, everyone there at the IDS office, for not only assisting our new chief public defenders in opening those new offices, but just all that you all do. You all really are all that we need in our office to make sure that everything is running as smoothly as possible. We know that you might have a title that is listed for you on the directory and on your paycheck, but many of you hold many hats and juggle many things. And so we really appreciate you all, and you really do a lot for us, and we appreciate it. And next, what I will do is I want to thank Peter Mack for his service. Is he on here? Is anybody I can't see really quickly okay. Yes. So I want to congratulate Mr. Peter Mack and thank him for his service. I want to give a little bit about him. Peter Mack Jr., is affectionately referred to as Pete, has a long history of serving others. Before law school, he served in the United States Army, 82nd Airborne Division here in North Carolina, as a communications operator and paratrooper, where he was stationed in North Carolina, South Carolina, Georgia, Italy, and Germany. Returning home from the Army, he next served as a police officer in Atlantic Beach and Havelock, small towns in eastern North Carolina. Pete attended North Carolina Central University from 1989 to 1992, and then again returned to Havelock, where he was in private practice from 1992 to 2003. He was appointed to the District Court bench in 2003, where he remained for many years, serving Craven, Carteret, and Pamlico counties. In 2021, he was appointed as Chief Public Defender for his district. His career as Chief Public Defender was a wonderful way for him to round out his career of serving others less fortunate than himself. So come March, you will find Pete, as he's told us, on his sailboat exploring the eastern seaboard with friends. Is Mr. Mack on here with us? If you are, sir, if you want to unmute, if you have any words or anything you would like to say. I can't see everybody, so if anybody can let me know if he is or isn't on here. Okay, maybe not. All right, well, if you are able to see him, I don't know if you may see him or not, since he's going to be on his sailboat. And I'm sure we all have got so much more to do than to be on the sailboat. But if you are able to see him, and if you could just congratulate him and give him some appreciation for his years of service, not only as a chief public defender, but just his long-standing career as an attorney and judge, as well as serving this country. We do appreciate him. And with that being said, I will move on to our staff report, as we agreed to amend the agenda and have Chad Boykin and Chris Sadler to give us a report on the new invoice system.
Thank you, Madam Chair. Thank you, everyone, for being here. I'm just going to do a quick screen share. Okay, thank you again, Madam Chair, and good morning, everyone. We will be covering a lot of ground today, and we will have a full question and answer session at the end. So we do ask that if you have any questions, feel free to jot those down, and please hold those questions until the end. Unfortunately, and for reasons I will describe today, the fee app system that we use to pay private assigned counsel, or PAC, is broken. The broken system I'm talking about does not apply to the capital and appellate system or to the contract system. Those are separate. However, it does apply to the PAC fee app system, which is the bulk of the bulk number of cases that we do pay. I will describe the issues and I will present a pilot program, the Online Attorney State Invoice System, or OASIS, that will modernize our operations and speed up payments. Finally, I will ask you, the Commission, to vote on adopting this program. OASIS will require some changes, but it is the way to accomplish an imperative goal. That goal is to pay our PAC within 30 days of completion of their work, using the most simple, efficient, and cost-effective means possible as soon as possible. To set the stage, we have three types of attorneys. We have public defenders. We met a lot of our new public defenders a moment ago. We have our MAC contractors, and we have private assigned counsel. Public defenders and contractors both get paid every 30 days, but our PAC attorneys, who are the backbone of our system and who work in all 100 counties, currently get paid anywhere from 75 days to as much as 1 year after completing their work and submitting their fee app. It is not uncommon right now for it to take 4 to 7 months. Why does it take so long to pay these fee apps? First, to answer that, we have to remember that PAC are paid by fee applications, and a staff of 5 people currently process about 11,000 fee apps per month. Wow. These apps come from 100 different counties with 100 different ways of doing things. It's approximately 132,000 fee apps per year. Those payments are in addition to issuing vendor payments, employee reimbursements, MAC contractor payments, expert payments, investigators, and paying our capital cases and appellate cases. The current process is 10 steps, and it requires the fee app to go through 5 different sets of hands. There is a chance for delay at every single stage in this very antiquated process. First, the attorney has to draft the fee app. They have to submit it to the judge. The judge has to review and sign. The judge has to get it to the clerk. The clerk has to, in some cases, clerks do some processing of their own. Again, it's different in different counties, but then the clerk has to get it to IDS. IDS receives it. We date stamp it to know when we got it. Then there's an audit process. If there's a fatal error at this stage, then we have to return it and they have to start all over again. And this is very late in the process. If it passes the audit, then it's coded and it's keyed. And when I say key, that's the same thing as paying. That's when it's entered into the system for payment. This is a big, long process. 2 recent incidents illustrate the extremity of the problem. In January, one of our chief PDs reported to us that a new judge on their first day opened a desk drawer. That drawer was stuffed full of unsigned fee applications. The month prior, in December of 2023, we were contacted by a judge who advised that he was sending over a stack of fee apps that he had just signed after having them for 1 year. On the front end, a fee app is often received by IDS 30 to 120 days after the attorney first submitted it to the court. The shortest time we see is about 7 days, and the longest is 1 year, as the examples in the prior slide showed. It frequently takes 30 to 120 days to reach IDS, and once we receive the fee app, we are currently only able to pay it after 60 to 80 days. The result is that the attorney is often awaiting payment for 4 to 7 months from completion of their work. Why 30 to 120 days on the front end? The front end problem is caused by the long 6-step front end process that is required before the app ever reaches IDS. There can be delays at every step. There's no tracking, and when we get calls, we can't report on a fee app unless we've received it. And all of these steps have to happen before we ever receive it or have any way to track it in the majority of counties. This is a sample redacted fee app, and this is not unusual. This attorney contacted us seeking a status and reported that the fee app they submitted the fee app to the court in July. You can see that the attorney signed this fee app on 7/21/23. This example shows that the app was signed by the attorney on the 21st of July and signed by the judge on October 4. There was a 3-month delay in step 2 out of 10 for this app. Similarly, this app was signed by the attorney on May 1 and signed by the judge on October 6. This is a 5-month period between those two events. The attorney called us in December, rightfully angry and demanding to know why he hadn't been paid for a fee app he submitted in May. This is a redacted email. We get dozens of these each week with lists of fee apps. In this example, the first group of apps were submitted on October 2nd and received by IDS on October 24. Over 91 days after submission. The second group were submitted on September 6th, and as of December 11, they were not received yet by IDS. The only way we know this detail is because our AP supervisor or our CFO, Aaron Gallagher or Shannon Simmons, who are both on the call today, one of those two people dug through hundreds or thousands of fee apps from that county to manually search for these on behalf of the request for the attorney. Management does this every day, and they do this to prevent staff who are issuing the payments from having to stop making those payments in order to do those searches. Our director has received these messages too from clerks, from judges, and from private assigned counsel. This is just the front end of the broken system. On the back end, we are facing payment delays of 60 to 80 days after receipt in order to issue payment. Historically, IDS has been able to pay fee apps 30 days from receipt. Beginning in October 2023, that 30 days became 60, became 80, and sometimes more. Why is it taking that long? The extraordinary payment delays that we are experiencing on the backside since October were explained in a memo that was posted to our website on December 5. December 5. There are 2 causes. In early October, the state of North Carolina implemented a new accounting system. It's NCFS. This system added several steps to the payment of each individual fee app and requires, on average, an additional 1 minute per fee app. That's approximately 11,000 minutes per month. About a week before NCFS went live, IDS was externally mandated to receive fee apps from the task queue in Odyssey or eCourts in the counties that are using that system. This requires individual retrieval, saving, sorting, and naming of each individual fee app and adds on average 2 to 6 minutes per fee app. Recognizing the hardship, AOC has generously provided us with a temporary position paid for by AOC through July 2024. So presently in all counties, we require twice as long to pay a fee app, and in the eCourts counties, we double or triple that. This is a time study that gives a visual flowchart representation of the time it takes to process 100 fee apps in NCFS using a paper process, that's this first section here, versus the Odyssey or eCourts process. In short, what used to take 10 minutes, and that's this first stage here, color-coded with the yellow, what used to take us 10 minutes now in the e-courts counties takes us 240 minutes. That's that individual retrieving, naming, sorting one at a time. This table gives the present status and a future forecast. The bottom line here is that what used to take 4 to 4.5 weeks in the old accounting system now takes us 9 weeks in the 95 non-e-courts counties. In the 5 e-courts counties, that same work takes 20 weeks. Those 5 e-courts counties will be 63 counties later this year, and next year it will be all 100 counties. This month, it's going to go from 5 counties to 17 counties. That's happening right now. If we don't act, today's crisis will be more than twice as bad next year. There is a clear and present danger at our door, and that danger is the potential collapse of our PAC system, which is the backbone of indigent defense in North Carolina. This is just a small sample of emails from December 2023 from PAC all across the state. The last one quoted describes the wasted, unpaid hours spent reviewing records, communicating with IDS, and communicating with the clerk just to try to determine whether a bunch of months-old FIAPs were ever received, which they weren't, meaning that this attorney had to resubmit them starting all over again. This, again, is not uncommon. Each attorney here has reported that they have stopped or are going to stop taking appointed cases because they cannot get paid in a reasonable time. Just in the last 24 hours, we have received 2 more of these emails. Some history is over the past 8 years, separate from this crisis. Over the past 8 years, IDS has already incurred a loss of 30% of our PAC roster. The 2,602 attorneys that we had in 2015 have fallen to 1,849. This has been caused in part by low hourly rates, overwhelming caseloads, and a payment system that was slow but tolerable. That payment system is no longer tolerable. We have to build, not empty our PAC rosters, and building those PAC rosters means lower caseloads for all of them. Lower caseloads means less burnout, and we have to modernize the way we do business in order to survive. We do have a plan that with some key innovations to the way we do business will allow us to meet the moral imperative to pay our PAC within 30 days of completion of their work. That plan is the Online Attorney State Invoice System, or OASIS for short. Here's how it works. IDS builds a simple, dedicated website for PAC to electronically invoice IDS after their FIAP has been submitted to e-courts. There are some limits. For example, OASIS will be used only in adult criminal cases and only in e-courts counties. But those e-courts counties are growing rapidly. Confidential cases like parent defense and juvenile are not compatible right now to OASIS, and for the time being, these cases will still be paid by FIAP. However, we are exploring moving these attorneys into the MAC contractor program to expedite payments to them and fix the problem for them. PAC will enter only the basic information that we need to pay them. There is no sensitive payee or client information. If the judge has requested a timesheet or if there are expense receipts needed, those are uploaded directly in the system. Once an invoice is submitted online, the attorney receives an email receipt of the invoice with the case numbers. This provides them a tracking system from the first time they submit, and that's a first-time innovation for IDS to be able to provide. Next, the digital data they enter feeds into a spreadsheet that is sent to IDS AP staff, accounts payable. NCFS does allow spreadsheets to be uploaded for payment. Doing this will save hundreds of hours of manual data re-entry. With those saved hours, staff will transition to performing a skilled audit function. They will make sure that there is a matching FIAP in e-courts before authorizing payment. One key to this process is that the app does not have to be judge signed for the invoice to be paid. The judge still sets the fee and still signs the FIAP, but if the app has been submitted and is a match, IDS will pay off the audited invoice. This is a significant change, but it is the fix to those long front-end delays. This proposed change begs a question. What if a judge reduces an award on a FIAP, but we have already paid it off the invoice? Judge reductions are very rare and they are statistically insignificant. But to provide for these instances, IDS will have a dedicated email address for judges to report reductions, FIAP rejections, or any other suspicious FIAP issues. If there is an overpayment, IDS will recoup the overage using existing processes. Counsel will attest to understanding this policy on the website. Judges will still sign the FIAPs, maintaining the existing procedure without delaying payment. OASIS builds on this process because the improved data collection can do something that individual judges' signatures alone can't. They give us data, and that data can reveal billing patterns and trends across jurisdictions that expose problematic billing. As an example, in 2022, the IDS research team, which is Chris Sadler's team, used data to uncover fraudulent billing, where an attorney was billing more than 24 hours worked in a single day repeatedly over a long period of time. Data analysis uncovered this, judicial approval did not. Finally, can IDS pay an invoice prior to there being a judge-signed FIAP? The answer is yes. IDS has the statutory authority under 7A 458, which holds that the fee to which an attorney who represents an indigent person is entitled shall be fixed in accordance with rules adopted by the Office of Indigent Defense Services. There's also years of precedent here. IDS has been setting the fees directly in capital and appellate cases for years, and we have also been doing this with the contractor system. OASIS will give IDS the ability to pay PAC in days instead of months. This slide gives a visual of how, by comparing the payment steps in the existing system on the left with the invoice system on the right. We looked at this long system before, it's 10 steps. Over here, what we have is an immediate data transfer. We have an email receipt. Then we do our internal audit. We verify that there's a matching FIAP. An automatic email notice is provided if there is an issue. If there's no issue, it goes right into a spreadsheet that can be uploaded for payment. No redundant data at re-entry. And that redundant data re-entry, to put it in context, we have almost 2,000 attorneys. We have 1,800 attorneys entering data that is re-entered by 5 people every day. That is, if you think about it, how long would it take 5 people to do the work of 1,800 people? That's one of the reasons it's taking us an extraordinary length of time right now. This fixes that. I would like to now welcome our research director, Christopher Sadler, who designed and programmed OASIS. There is a short introductory video here, and then he's going to actually give you a demonstration of the system. What you're going to see is not the final system. What you're going to see is a test site that he built quickly to show the proof of concept. The final system will be a lot better and have a lot more bells and whistles.
Hi, my name is Christopher Sadler, and I'm the research director here at IDS. Today, I'm going to demonstrate the new online attorney state invoice system. This system is something we're really proud of and excited to show you. So thank you for joining us. Hi, my name is Christopher Sadler, and I'm the research director here at IDS. Today, I'm going to demonstrate the new online attorney state.
I like that so much, I showed it to you twice. This is the actual demonstration, and let's hope this works.
This page was developed solely as a proof of concept for the commission. If OASIS is approved for pilot, the final page will feature improved looks, feel, and functionality. PAC attorneys will register with IDS and be issued login credentials. Accessing the page login screen with a password and 2-factor authentication to meet judicial branch web security standards. Payee information is maintained by the NC Office of State Controller. No payee information such as tax ID number is shared, transmitted, or stored using OASIS. If any firm or payee information has changed, attorneys are advised how to provide the updated information to the Office of State Controller. If there are no changes, attorneys select No and move to the attestation reminder button. Next is an error avoidance mechanism where attorneys will be prompted to click yes or no to describe whether any of the attorney's cases are capital or were potentially capital or appellate. These cases are paid using a different system. This question helps avoid errors and potential duplicate payments. If no, the attorney moves on to entering a case. First, we select the appropriate county using the drop-down menu. The selections include the county name and the 3-digit county code used by eCourts. Here, we will select Wake County. Next, we enter the file number. It is programmed for the 2-digit year, the criminal code, and 6-digit sequence number to help avoid errors. The online process itself avoids handwriting and readability issues, which are a frequent cause of fee app returns. Next, we select whether the app is an interim or final fee. The first hypothetical case will be an interim. Therefore, we are asked for the last day we worked on the case. The calendar tool appears and we select February 1st, 2024. Next, we select District or Superior Court by clicking the radio button. Then, using the drop-down menu, we select the highest original charge, which has the appropriate hourly rate programmed. This is another error reduction mechanism, preventing us from applying the wrong hourly rate and eliminating the need for referencing the rate chart. Here, we select a high-level felony. Next, we enter our time in court waiting, and time out of court. If the judge requires a timesheet, there will be a means of uploading it at this stage. Next, we bill for 20 single-sided copies. And again, OASIS is programmed to apply the 10-cent per page rate, avoiding inaccurate billing. We now enter 10 double-sided copies, and OASIS automatically applies the 16-cent rate. Finally, we drove 45 miles out of county on this case. Here, OASIS applies the IDS mileage rate of 0.625 cents per mile. Finally, for other expenses, we enter $25.01. Because this exceeds the $25 threshold, we must provide receipts for all these expenses. The Choose File Upload box appears and allows receipts to be uploaded. Notice the total amount populates based on all of the data entered. Here, we are at $566.74. We can now add this fee application. Since we want to add another fee application to this invoice, we now click Add Fee Application. Again, we will use Wake County. We'll input our case number. And then at this time, we'll select Final. Since this is a final fee, we must enter a disposition date. We will select February 1st, 2024 as the final disposition date. Next, we must answer whether the client was convicted, not convicted, or whether the attorney withdrew. If the client was convicted, then we know the case is recoupment eligible. Here we select yes for conviction, we select district court, and a low-level felony for highest charge. We now enter our hours. We have no copies, mileage, or other expenses, and the math is done for us. The total amount being billed for this case is $390. Now you can see we get a grand total which is the sum of all cases entered. Here, the grand total for the invoice is $956.74. We then click the final use agreement. We have a CAPTCHA as additional web security. When we are ready, click submit, and we're done. Once submitted, we will receive an email receipt documenting the case invoiced, providing attorneys a tracking mechanism for the first time ever. Thank you for your time.
Okay, thank you, Chris, for that demonstration. So web security is a fact of life for any online system. So to repeat some of the things that Mr. Sadler said, first, no sensitive payee or client information is involved in this system. That's sometimes referred to as PII, or personally identifying information. Payee info, such as the tax ID number, is held by the Office of State Controller, not IDS, and is not used on fee apps or invoices. It used to be on the fee apps. It's been removed in October. We still do get some that have it on there. They're using the old form. But for the purposes of this website and invoice mechanism, there is no PII involved. No defendant data is needed for invoices, no client names, no social security number, no addresses. The website, consistent with NCAOC web security protocols, will use two-factor authentication and industry standard web security protocols. Security updates, patches, and maintenance will be done by our existing vendor, Tomatillo Design, who has done excellent work for us on our main website for years. In addition to web security, we also have a plan for physical security through expanded audit. IDS worked with the Director of AOC Internal Audit, Jordan Samuel, who I believe may have joined us on the call today, to develop a two-layer audit system with additional safeguards. The first layer of this audit security system is that all invoices that meet certain threshold criteria will be automatically sent to management for a direct audit. These are things that we audit on the fee apps anyway, so it'll just be replicated in this system. These include cases where a certain amount of hours or a certain amount of dollars billed or a certain amount of mileage exceeds a certain threshold, and also any unusual case types, including potentially capital or appellate cases, because those get paid in a different system and we don't want accidental duplicate payments. And it also includes any class 3 misdemeanors, because those require some legal review to make sure there's entitlement to counsel at state expense. So this is layer 1. Layer 2 is that for all cases that do pass this first criteria, the system will randomly send an approved percentage of cases for audit by staff. Staff will verify that a fee app for the case invoiced is in Odyssey eCourts and that the billed amounts do match. They will flag any other issues and either approve or disapprove payment. A sample daily audit sheet is shown on this slide on the left-hand side. Cases approved are uploaded to NCAS for payment. Once uploaded through the spreadsheet, payment usually takes approximately 3 days. So this is a sample of the audit sheet that our staff will go through for layer 2. What happens if a case fails audit? What happens there is that an email describing the reason for the rejection will be auto-generated and sent to the attorney. It will also include instructions on correcting the issue and how to resubmit that invoice. As an additional safeguard, any case that is rejected will be flagged for audit when resubmitted. This will prevent taking a gamble on immediate resubmission without correcting the issue. Statistically speaking, once an attorney has submitted 7 file numbers for payment, their probability of audit is almost 100%. And as you saw, you can invoice multiple cases in one invoice. So you might have 7 file numbers in one invoice. You might have 10, you might have 1 or 2. But once you've hit 7, your probability of audit is almost 100%. We'll conclude with a look at the system benefits, starting with a look at how the system will reduce errors in fee app returns. So fee app returns are a long-standing problem, and our staff return approximately 25 to 40 fee apps per week per person. That comes to between 6,500 and 10,400 fee app returns per year. That translates to 1 or 2 full cases of copy paper annually. Those cases of copy paper are 50 pounds each, so we return 1 to 2 of those every single year. Returns delay payment late in the process, frustrating the attorney, and they waste tax dollars because they take up clerk, judge, and staff time. On the right is a return cover sheet with the myriad issues that cause FIAPs to be returned. Those include illegibility, missing information, billing at the wrong rates, and math errors. This is a FIAP that was returned because all of the payee information was completely missing. With an online invoice system, this will not happen because the payees have login credentials, we know who they are, and they have no need to re-enter their payee information over and over each time. Also, there are boxes that are necessary that will require information to be entered before moving forward. So there's no more returns for missing information. Also, no returns for legibility issues or handwriting that our staff can't read because the information is digital. OASIS prevents other common errors by preventing blank fields, automatically applying the correct hourly rate based on the case type selected, and doing the math for the user, preventing returns due to handwriting issues and math errors, and it provides an important real-time policy information, such as reminders that if you are in court waiting for 4 hours and you are working 4 appointed cases that day, you need to bill 1 hour waiting for each of those 4 cases, not 4 hours waiting for each case, which would be 16 hours. Having that policy reminder is something that we don't have on the FIAP, but we will be able to have in this FIAP system. Other policy reminders can be popped up when you hover over the information button. We believe that this is a common error that real-time reminders can help prevent, saving tax funds and ensuring accurate billing and payment. Other benefits of the pilot include the first-time ability to pay back in days instead of months. This, we hope, will slow PAC losses and help us start to rebuild our PAC rosters. We can now also email invoice receipts directly to the attorney automatically, which provides a tracking system for the first time. Returns and rejections are immediate, and they no longer happen months down the road late in the process. They happen early in the process so that they can be fixed quickly. Digital data increases our audit capability. Waste reduction and AP staff will no longer have to manually re-enter data. FIAP processes remain intact, and the FIAPs remain the court record, and they remain in process for recoupment purposes. We'll be talking a little bit more about recoupment in our setup debt update later, but the FIAP does more than just provide the payment vehicle to the attorney. They are also the court record, and they also provide the recoupment vehicle. And in some cases, that recoupment process is delaying payment. I had a call this week from an attorney who had a FIAP that the clerks were holding up because they wanted to make sure that the judge signed in the right box. And, you know, we had to go over the fact that IDS policy is no matter which box on a juvenile FIAP the judge signs, we accept it, we'll pay it no matter what. But the clerks want to make sure they're doing their job right, and we don't want other parts of the FIAP mechanism to get in the way of being able to pay our attorneys on time. So the bottom line here is that OASIS makes NCFS work for IDS instead of making IDS work for NCFS. What that means is this new state accounting system has slowed us down tremendously. This will make the benefits of that system available to us and make it something that helps us instead of hurting us. So this is the final slide. This is our proposed rollout. If the commission votes today to authorize this pilot, we intend a small rollout limited to 10 to 15 select attorneys. They will test and improve the system and give us feedback so that we can make it the best it can be. The system will roll out along with e-courts since they work in tandem. Without the ability to do that audit of the FIAPs in e-courts, this system can't function. So it's going to mirror and go with the e-courts rollouts. So our full implementation goal, if approved by the commission, would be mid-2025. I thank you all for giving this important project your consideration, and I will now open up the floor for questions prior to the commission vote. And again, I thank you for your time. I know this was pretty involved. So any questions, feel free to raise your hands, and I guess Max will direct traffic.
Yep.
Chad, I have about 1,000 questions. This is Staples Hughes. Is it okay if I proceed?
Absolutely.
Okay. Number one, this is a great presentation. Pardon me. think it laid out the problem, and the problem is horrible. And want to applaud everybody who was involved in this for putting this idea together. And some of my questions may be kind of questions that, and I'll let you be the judge of this, that don't really need to waste the whole commission's time. And you can just say in response to some of them, call me next week, and I will call you next week for the explanation. One thing I think that is really important that does occur to me is that as this is coming together, and certainly when it's finalized, there really needs to be a good PR campaign to let everybody know, everybody, their brother, sister, and their cousin know that the delay has been eliminated and you don't need to worry about that anymore. So just a suggestion that ought to put some thought into that. I'm sure you will. Now, here's where we get into the stuff where please feel free to say, call me next week. The kinds of safeguards that you're talking about building into this system for security, are they already in place for other IDS sort of payment schemes like contracts and so forth?
I would say there's more security here than those other systems.
Okay.
The other systems rely on some of that PII. This is Aaron Gallagher, by the way. So we do transmit information. When I think of our capital attorneys, our capital experts, our non-capital experts, we get information online, and I've discussed it with Mary as to ways we can limit our exposure there. This addresses a lot of that. And one of the ways we got to this system was working with Chris to see how we could automate some of those smaller tasks that we carry out every month. And one of the things we automated was the MAC payments. They come in a spreadsheet from the Durham office that compiles all that data. Angela Henderson's on the call as our contracts administrator. What we did is we worked on a way with Chris so we could get the data for the MAC payments, put it into the format that is compatible with the new state financial system, and upload it directly. So we're transmitting a lot less PII there. So those other systems actually, I think, have a few more areas of concern than this. This eliminates some of those, and we hope to take this and the success that we expect with this and apply it to other systems across the board.
Thank you.
Got muted.
Yeah, I don't know what that was about. Now, this is a second question, and this, why, if IDS is, and the statute that you cited that talks about per idea, people, attorneys paid per IDS rules. My question is, and I'm gonna pose two potential answers to this question and then let you actually correct me. Why don't we just bypass judges signing fee apps altogether? And it occurs to me that there are probably two responses to that. One is it's a double check on fraud, basically, or problems more broadly. And the other would be a political, I guess what you would call a political consideration of not infringing on judges' perceived ambit of their power. Now, I mean, why don't we just bypass judges in the fee app process?
Max, could you unmute you for that?
Unmute you?
Yeah.
Yes.
All okay on your end?
My device is muted.
We heard a little something, Mary. It sounded like from you. If you try, if someone over there is trying to talk.
Okay. Sorry about this, folks. Okay, can you hear me now?
Yes, we can hear you.
So Staples, I think the big answer to that is as long as we have a recoupment scheme that relies on judges entering a civil judgment in cases where the client has been convicted, we're going to need judges to sign the applications and enter those orders. And I also do believe it's a little bit of a check, a little bit more of a control in the counties where we don't have regional defenders. Judges don't sign fiats in counties where we have regional defenders, but we have those regional defenders kind of providing a little bit of oversight and some audit control, plus our contracts administrator. And, you know, I think politically, the judges are still going to have the opportunity here to reduce fees. Again, is that happens so rarely. One of our AP staff, Priscilla, right, who processes probably 15,000 fiats a year, says if she sees 2 or 3 where a judge has reduced the fees, that's a lot. So it rarely, if ever, happens. Mm-hmm. And then I see that John Rubin is on the call, and he might be able to provide some kind of backdrop on the history and IDS's authority and why judges still sign fiats. If John, hate to call on you unwittingly, but I know you're out there in the room somewhere.
Yes. Well, you know, years ago, IDS did take payment authority away in capital cases. So you do have the authority, but I do get, I think your point that they're going to be entering the recoupment orders anyway is really significant. And as long as they have to give notice and an opportunity to the defendant about the amount. So it makes complete sense to have them involved in that process. Years ago, it was left with the judges because IDS just wasn't in a position to deal with 200,000 fiats, unlike in the capital and the appellate area. You know, you have more capacity now, but that recoupment piece is big. Plus, there is that little bit of a check and an opportunity, even if judges aren't reducing fees, an opportunity for judges to just flag it, to just shoot an email, or I think Mary you have some process for that will allow judges to flag questionable fee apps.
We will. And, you know, and we're happy to provide, I know there are some chief district court judges, I'm thinking of one in particular, who have been good, you know, they kind of pride themselves on being good stewards of taxpayer resources, and we provide them with court or semi-annual reports on tax spending in their district, and we're happy to continue to do those things and partner with interested judges. In fact, I appreciate that personally. Yeah, this I think kind of gives us the judges still have that bit of oversight, and we get a lot more ability to kind of crunch this data and learn from it. So, yeah.
And ideally, what would happen here is, you know, in the ideal world, what we have built would be built into eCourse, and it would just be one thing, right? But that didn't happen. So we're sort of building what ideally would have been built into the system, which is digital data instead of like thousands of scanned fiats. And one more reason why the judge is signing that I would offer is that I have every confidence in the site that we're going to build and in the process and programming. I want to give all the credit to Chris Sadler, who's been doing the work on this, but this is also a backstop, just in case, worst case scenario, something goes wrong, the existing system is still happening. So we can dip right back into that, and there won't be a giant disruption if anything goes wrong, because we'll still have the fiats, we'll still be able to do what we're doing now if we have to. But this is something built on top of that. So it does provide, at least in the beginning, a fail-safe if anything went wrong.
Okay, got it. I got one more question, really more of an observation. You know, a breach of security in a system like this. I mean, I'm so glad to hear that you guys are focused on the back end security and personal information. I don't follow all how you actually do that, of course, but because a breach would be catastrophic for any number of reasons. And also IDS, it seems to me, is the kind of entity that some creep out there in the world who wanted to steal data might target, perceiving it to be a sort of not hyper secure sort of environment. So I want to urge everybody involved to make it hyper secure. And in that spirit, I'm just, you know, I hear you say that the existing vendor who has worked on the website up to this point will be maintaining things. I just, you know, I trust you guys to vet them. I obviously don't live in that world, but I would say that you would certainly want to have discussions with them about their own security. I'm assuming that they are attentive to that, but it seems to me it's worth, you know, vetting their own security, because if they get a breach, we get a breach, and all their other clients. Thanks. I appreciate your responses. It's a great presentation. And I'll look forward to everybody else's questions and observations.
I just like to make one comment, if I may. If there were any sort of breach, this is not what I don't think anyone would deem a target-rich environment.
Well, that's what I was gonna share
There
with
is no-
Staples, is that the important information that a hacker would be after is over there in Odyssey.
Yes.
And on eCourts, right? That's where the social security numbers are and the client names and all of that. And then, I guess in NCFS, in the financial system, you have your accounting system of record. This is kind of just an information flow-through portal. No private information is going to go through this portal, no client names, no social security numbers. Security is important, and our folks have
Absolutely
looked into that, and they're meeting with AOC TSD folks on Tuesday to go over that again. The same people, as I understand it, our website is hosted on the same web servers that eCourts is hosted on, Amazon Web Servers, and if that gets hacked, the whole world is going down. So this is a pretty low risk operation. If the website got locked down, we could cut it down and the guy could rebuild it the next day. I might be oversimplifying things, Chris. Chris says I'm not oversimplifying things, so it's
The most information you would get if there was some sort of breach with this is the attorneys that do work for IDS, how many hours they billed us on a particular case, and how much we paid them on that particular case.
Which is public
all
record.
public record.
Which is all public record. And that, I don't know what one would do with that other than say, haha, I know you billed IDS for $15,000 last year. But that's public information as it already exists. There's nothing protected in what we're gathering, and we built it and we set out to build it that way because we anticipated questions like yours, Staples, and we anticipate those kinds of questions when we meet with AOC next week. We have to do something that allows us to pay people quicker without putting ourselves in jeopardy, and I feel like what we've come up with will enable us to do that.
Yeah, I hear you, and I believe you, but I also believe that there's a rule of thumb out there in the world in the digital age, which is if something can go wrong, you better identify that thing and do something about it. And eternal vigilance is what is it needs. Where there are interlocking systems, and again, I'm hampered because I don't know what I'm talking about, except insofar as I observe that interlocking systems always present some degree of security risk. So it ain't that I'm questioning your competence or anybody else's competence in particular. Again, if something can go wrong, sooner or later it will go wrong. And a clever thief can figure out a way to gain information in a way that may not be completely apparent. I'm talking about sensitive information. I'm just saying, it sounds like a great idea. I've already decided how I want to vote personally, but please be paranoid.
No one is more paranoid than we are. Especially because we're floating this thing and it's on us, so yeah, and I appreciate that, Staples. We are meeting with AOC's TSD security people next week to make sure this is as robust as possible. And like Aaron said, part of the plan here is that if anybody steals information, it's public information they're allowed to get anyway. At best, you'll get an email address, a file number, and an amount billed, and what cases they were at.
But I will say what has kept me up at night the past 2 years. I've been here, next week makes 2 years during my tenure with IDS. And what does keep me up at night are those 135,000 FIAPs, paper copies of which float around courthouses, judges' offices, clerks' desks, the courier between Murphy and Raleigh, that include people's signatures, addresses, social security numbers. That's the kind of stuff that if someone got their hands on, there could be a major issue. This eliminates all of that.
I also,
Can I ask a question about that? So in that process, I noted that you all spoke about, and if it was included in the little example or the overview that was on video, I missed it. But is there not have you all thought about having it be where the judges can actually sign electronically too, especially since we're going to e-courts and all our signatures are going to be there, and we'll eventually get used to the whole e-courts and signing everything online and all of that. Is there a way to eliminate because I know in here on this, and then what you included in the PowerPoint, it talked about how the judges would still need to submit the actual fee app, and then it has to be signed by the judge, and then once that's signed, all of that is uploaded. If I read that and heard correctly.
So the judges will sign the fee apps electronically in e-courts in the Odyssey counties. We will be paying the fee apps upon submission, so before judicial signature. So if the judge spots a problem with the fee app when they sign it, they need to email us on this dedicated email address, and we will go back to the attorney and get the money back if we've already paid them. We anticipate that will happen very, very rarely because it happens very, very rarely. So they're still going to sign fee apps. In an ideal world, as Chad said, all of this would have rolled out differently, but we don't live in an ideal world. We live in the world we live in. And this is the best solution we're able to come up with to the crisis that we're in.
And I can give a very specific example that taps into what our chair has said and what Mary is saying. On my journey from my office in this building to this room this morning, and this is the God's honest truth, a member of the Odyssey team was on the phone in his cubicle, and I just happened to hear him speaking to somebody. And he mentioned that Odyssey does not include off the shelf. It includes an additional cost and additional license. This is something Chris can explain better. Something called OCR,
right,
which allows you to take a scanned document and make it searchable and pull data from it. Had Odyssey included that, that may have addressed this issue we're trying to fix right now, but it does not.
Well,
we can't take the scanned fee apps that are in Odyssey that come to us through the task queue and pull off the relevant information we need to pay our attorneys. And that has been my observation for the past couple of years. And I literally heard someone tell somebody today, Odyssey doesn't, and why? That's beyond me, but it doesn't have it. Therefore, we have taken it upon ourselves to do this.
Yeah, so we just gotta we gotta deal with it. I hear your frustration. We appreciate the frustration, especially in regards to Staples wanting you all to be really, really concerned about that and other things. So we appreciate that. But I'm sorry that I missed that because I heard you speak about the judge's signature, but I didn't quite catch that that will be done electronically too. So with that being said, I think that will eliminate the time in between and all of that good stuff, at least help with that. Mayor, did you have something else? We do have some other hands of commissioners up too, so I want to try to get to folks.
Okay, sure. I wasn't done with
Okay.
Staples' question, but that's okay. You go.
Okay. No, if you want to go there, and then I see Art, and then Brian Cromwell and Kate. That's who I see right now, but I'll get to everybody. Did you want to address something more?
No, I just wanted to remind Staples that this was not a system that was built by lawyers. It was built by Christopher Sadler with input from Aaron and Jamie Blackwell and people who have a very, very sophisticated understanding of the sorts of security issues that you're concerned about. Way over my head.
Yeah, I get that, but I also realize that there is a relationship between e-courts and this proposed system, which again, I think this sounds great, but I'm just saying, you mentioned e-courts in the same breath with security and functionality, and boy, does, a lot of red lights go off on my personal dashboard.
All right, thank you.
Okay.
Art,
I think Commissioner Fenhagen had her hand raised the
He
longest
did,
so far.
but Art had raised his hand earlier and had it raised for quite some time, as well as Brian, and then I'm gonna move to Kate. And usually I would go with ladies first, but I did see their hands up first.
Thank you,
Art,
Madam
if you
Chair. Just one question, and it goes to what Staples was just saying. We all know the issues that have been involved with e-courts. I know they're getting better. I'm not really privy to much of it except for what's happening in DAC and e-courts. But the question I have is, does this system work independently? I know it's only going to issues with counties with e-courts, but does this system have independent functioning outside of what e-courts require?
Yeah,
That's a great question, and my exact question too, Art.
It's a separate system. It relies on the ability of our accounts payable staffer to be able to view the FIAP in e-courts, right?
Okay.
To be able to audit, but they are separate systems.
I am totally satisfied. That was my question, and thank you, Madam Chair.
Awesome. So that, just to clarify that a little more too, Mary. So that means that we will, if we start this pilot, I know we're starting to, if we approve this, we will start the pilot rollout in the e-courts counties. But is it possible to go ahead and include maybe another county just so we can see how, okay, I got you. I see you shaking your head.
Well, we have to, because we're still going to have to we have to be able to audit in e-courts and
Yeah,
I was just wondering if there was a way so we could see for sure how it effectively works either way. But yes, thank you for that.
Yeah, we would.
Brian, go ahead. I'm sorry.
We would love to be able to do this in the non-pilot or non-e-courts counties, and we really want to. The problem is we don't receive those until we get them in the mail, if it's a paper county. So we have no way to audit, especially as soon as it's turned in, which is the problem. So this is tied to e-courts only in that we need it to do those audits. That's all.
Okay. So can I get y'all to do me a favor? Yes. Can I get y'all to do me a favor? And if you're done with the PowerPoint, can you take that down? That way we can see anybody that's speaking over there, especially in you all's room. We can see you on a full screen here. And
yes.
Thank you. Thank you so much. Brian Cromwell, I think I saw your hand up next, and then I'm coming to you, Kate.
So this question may be misinformed because nobody else seems to have thought about it, but it's a financial question. Did I misunderstand? Are we advancing payment and then we will be reimbursed by the court after they sign and review it?
No, not so much. What we are doing is there's going to be a FIAP that has been submitted into e-courts. And simultaneously or whenever the attorney decides to do it, but they will have a strong incentive to do it at the same time or very quickly, is they will do this invoice, which comes to us electronically immediately. What we are doing is paying off of that invoice as once we have matched and made sure that that fiat does exist and that the amounts are the same. So we are not advancing funds and getting refunded. That refund part would only come in if, for example, an attorney submits a fiat and an invoice, and we pay that invoice and we match and see that the fiat that has been submitted is for the same amount. And if 3 months later, 8 weeks later, whenever later, the judge writes in to the dedicated email address and says, hey, I understand I need to report this. If I have reduced a fiat, if the attorney billed $500 and I cut it down to $400 for whatever reason, that is when, if the judge lets us know that they reduced it, we would have to go and seek that $100 with the same process we do now if there is any kind of accidental overpayment or something like that. We expect that to be very rare because it's very rare now that the judges reduce a fiat, but we do have that contingency, and that would be the only time we would be seeking any kind of recoupment.
I did see that, but I also saw in the example that there was a drawer full of FIAPs that hadn't been reviewed. I just want to make sure that there won't be a very large dollar amount in between us approving the FIAP and judges making their final determination. It sounds like that you guys are comfortable that it's going to be a minuscule amount, but I want to keep my eye on that prize, because if that number is large, we could be out quite a bit over a short period of time. Does that make sense?
Absolutely. And what we do have on the back end, and I'll maybe ask Chris to give detail on this, but we are able to go in after the fact and use the data of the invoices to look at, if I'm not correct, the case information that's in the system to match up if there's a case. Would we be able to do that on the fiscal side to make sure that there were no changes after the fact?
One last thing, and I'm throwing this out there for us to at least think about. I'm not suggesting that any of our PAC attorneys are engaging in fraud, but I have seen some PAC attorneys overbill, and some of those FIAPs get rejected. I want to make sure that we're not, again, paying monies that will be eventually turned back by a court because of overbilling. So I'm like Staples. I love this system. I think it's a great idea. I'm concerned about fraud, waste, and abuse.
So if I could, and Chris can help me here, this system is going to give us so many more tools to spot fraud, waste, and abuse. On the one hand, a handful of judges cut a handful of FIAPs every year to the tune of maybe 4 figures, right? On the other hand, we have situations like the one we reported on last year where an attorney was billing 7,000 hours in a year. That's 17 hours a day, 365 days a year, because he took the FIAPs to 10 different judges, and there was no ability for anybody to spot the overage. This system gives us data where Chris can pull it, and that you can see actual patterns. And we could probably spend a whole meeting on this, but for example, if somebody is doing honest hourly billing, their FIAPs, you could plot them on a graph for, say, a certain type of case, low-level felony, and it's going to be a bell curve, right? Because most of the FIAPs are going to be up there on the big part of the bell. That's the average amount of time you spend on a case. You're going to have outliers on both sides, something that you got dismissed right away or something you went to trial on. The people who don't bill honestly, you plot it and it's not that bell curve. And this gives us that kind of data. If anybody has suspicions about any kind of attorney, we can plot that and start looking at them real hard. It is really rare, Brian, right? 99% of our folks are honest and they are working hard and they are leaving money on the table and underbilling us in a lot of cases. I truly believe that. But once in a while, somebody comes along and gives us a black eye and it's bad and it costs a lot of money. This is a much better way to eliminate or to spot fraud and waste and abuse. So there are just a lot of good reasons to do this. Yeah.
Fair point, and I don't want to beat this dead horse, but I'm going to reiterate what Staples said. The
Mhm.
one time that you don't anticipate someone's going to take advantage of a system is
They
when they
will.
take advantage of the system. Will there be a dedicated person at IDS auditing these fee apps?
The current accounts payable staff will be auditing 50, some very significant percentage of the fee apps every day. And then the ones, as Chad said in the presentation, there will be certain criteria that we're not making public that will elevate it. And it would be reviewed by Aaron or by Shannon Simmons.
And I do want to make a point that the fee apps forms that we use now include a lot of data. But as Chad so eloquently told the story at the beginning of his presentation, it takes us a great deal of time to get attorneys paid. And one of the ways that we expedite that process is we only capture certain amounts of data. The fee app form as written has 3 fields for time and a field for expenses. The times are your time in court, your time waiting in court, and your time out of court. But for expediency's sake, and this is the assistant that I inherited, and I've been asking questions since I got here, and Chris joined after me, so you've got some fresh eyes looking at it. Well, if we've got 3 different buckets of time, but for expediency's sake, we only put the total hours into the payment system, that only gives Chris so much data to work with. But this system now would capture all 3 of those fields of time. So we can look at a particular type of case, a low-level felony, as Mary said, and say, well, let's look at that curve. Well, we've got some outliers here. Most people spend X amount of hours in court, out of court, waiting in court on these kinds of cases. But now we're seeing certain attorneys or an attorney, he's billing or she's billing 2 and 3 and 4 times more time waiting in court than everybody else. So we're going to have way more data. We're going to have a faster payment and a more robust data set for the research team. So this is really going to serve 2 purposes. And it'll actually help us eliminate fraud, I believe, versus creating a chance for more chances of people to try and commit fraud.
Thank you.
Can I go back and I know, and sorry, Brian and Kate, it's kind of piggybacking off of what Brian was just speaking about, but going back, and I know I brought this up before, but going back to the judge signature part, is it not a way for us to just have them to submit the fee apps where they're doing it electronically, that gets dropped into the judge's queue for their signature right then and there, and then they sign it, and then we pay, and it doesn't have to be this situation of paying before the one comes back with the judge's signature and possibly this reduction and all of that. Because from what I hear about the e-court system, if there's something for me as a judge that I need to sign, it's put in my little queue, and I have to make sure I go and handle all those things in my queue, and for it to not stack up unnecessarily. And for us to keep going and getting done.
That's the e-court's task queue, and that's what was provided to us by means of fiat payment through e-courts, and that is why, if you kind of go back to Chad's slide, that's what's caused our processing time to go from
1 minute.
1 minute to 6 minutes, multiplied by 11,000 fee apps if we're statewide. That is what's causing the back end processing. Yeah, there's yeah.
And there's also
all right, but if possibly that could be explored later if something new comes about and all of that good stuff.
There's also and Chad made a good point in that we're only paying fee apps right now in the task queue significantly in Mecklenburg, because most of Wake County is in MAC, right? So we're having real problems in Mecklenburg with things getting from the judge's task queue into the IDS fiat payment task queue. We don't know where the breakdown is. Maybe it's training, maybe it will get better. But when we're looking at complaints from attorneys, we're seeing about half of the signed fee apps are getting into our task queue. And we have one staffer who can go into the cases, Chad can go into the cases, and he can see that the fee app is there and that it's been signed by a judge, but it's not in our task queue to download. So
Gotcha.
that's why we're scrambling here. That is the crisis. Okay.
All right, Kate, I see your hand, and then Marion, I see your question in the chat, and I can try to help answer that. And Mary, if you all can look at that too, but I have some information on that myself. But yes, Kate.
Thank you. So Yeah, I just want to also thank Chad and Chris and everyone who has worked on this. It seems like it's an innovative response to what is a terrible problem for dwindling PAC attorneys and going to only be made much, much worse by Odyssey. So I am sure there are tweaks, and I'm just very excited, and I'm so glad to see this as a possibility. I have a couple questions about it. I assume the trade-off for PAC attorneys is that in terms of getting their money sooner, they are going to have to do FIAPs and enter them into the system, and then do a separate, for each of their cases, a separate OASIS entry. And I'm wondering, first of all, if for heavy district court caseloads, whether that's going to seem like another burden for them, or if the payoff is, more important. And secondly, do attorneys have a choice? So can they go ahead and just wait on the long process if that's their choice? And will that make any work harder for the IDS folks to be having them come in different ways?
So unfortunately, it is going to be a little bit more work for the attorneys, and they're going to have to key, or their staff is going to have to key, a relatively minimal amount of information, as well as submit a FIAP. The trade-off for that is if we don't go to the system, it's only going to get worse. It's only going to get worse for them. And we think sure payment and in a system where they're going to get a receipt where they know IDS got their FIAP is hopefully worth the trade-off for them. In terms of can they opt in or opt out, unfortunately, no. If we do this, it's going to have to be all or nothing. If we do this and it works, there's no feasible way to pay some through the task queue and some through the system. So it's not, it's not ideal, right? This isn't a magic solution. It's I can't overstate how difficult the past 5 months have been for our fiscal staff and our accounts payable staff. They've been working overtime. We have temp labor. They've been working like crazy, and it's terrible. And it's worse for the attorneys who aren't getting paid. We've got to do something. We've got to do something.
And I would add one, this is something we didn't talk about because we don't know yet, but there is the potential to get a web plugin that would allow information entered into the system to be transposed on the FIAP so that what they enter would go onto the FIAP. They could then upload the FIAP. The OASIS system doesn't need as much information as a FIAP does. We wanted to keep it minimal partly for that reason. If they do have to do two things, we want that second thing to be as little as possible and only what we need to give them payment. But there's the possibility that there is a plugin that would allow info transposed onto the FIAP. So it would have the amount you're billing, the hours, the county and the file number, and then they would manually enter, the check boxes and the other things. That's something we're looking at, but we don't want to present it yet because we don't have enough information. But that could be something that would make it more of a one process instead of two a little bit down the road. So thank you for that.
Yeah, I had originally thought, well, we could do, maybe, ASC could do a guidance file that would create a FIAP from which we could scoop the data for payment. But as Aaron alluded to earlier, the guidance file basically makes a PDF, and you don't capture that keyed data, so that doesn't help us, and it doesn't have an OCR thing. But yeah, we might be able to make it better down the road, I think is what Chad is saying, but this is the best we can do right now.
And we also did have a meeting with the BAPM team. That's the team sort of behind eCourts to propose that idea. Can we just take this idea and put it into eCourts so that they just do one thing, enter it into eCourts as data, and it goes immediately? And they thought that was a great idea, but it was basically, no, we can't do that. It would cost too much time and programming, and we're in the middle of rolling this out. And basically, it's up to us to figure this out.
All right, thank you for that. Miriam, to your question, Miriam has in the chat, has IDS established general ranges of hours per type of case? Is that curve information listed anywhere for PAC attorneys and judges to see? I know you all can help me more with this, Mary, but I just recall having been in private practice and a PAC attorney, I never received like an official list or anything, but we knew that there was some general range of hours. And as a judge, I definitely did not ever receive any kind of general list of hours. But I know, like, for instance, if you try to get a fee app and somebody says they spent 10 hours on a simple possession of marijuana charge, that's clearly excessive for a matter like that that could be resolved in an hour or two. Of course, depending on somebody's experience and all of that good stuff. But did you all have anything more to add? I'm not aware of any lists or anything, but if there is, could you let us know if there is one?
Yeah, I can add to that. If you reach out to me, I can send you something. It will come with quite a few caveats, but there is something similar. Christopher.a.sadler@nccourts.org. I anticipate to have something that we'll put on the website and distribute to people probably by June or July. We are redoing what was done in the past. We've made some modifications to hopefully provide a better tool for people to use, along with some guidance of it. But yeah, if you reach out to me, I can get you something, and there will be some caveats to it. But there is something.
But there isn't like a place on our website.
No. Correct. Yeah,
Okay.
you'd have to reach out to me. I'll send it to you and we can talk and walk through it, as well as some of the pros and cons to it. But yeah, I would say if you're interested and really want a tool to use, I would wait to about June or July, when we have something better developed that's user-friendly and likely more accurate.
Okay. All right. And I will also say, to throw this out there, just based on my prior experience and knowledge, that trying to make a comparison with the amount, or you should not make a comparison with the amount of hours that an assistant public defender or the folks in the actual PD's office report on their fee applications that they have to submit versus what the actual private assigned counsel attorneys submit. Those are very different. And so I just want to throw that out there. I saw other hands in regards to this. I think the next one I saw was Nicole Malenko Neely. And then I see you.
Yes.
Ms. Franco.
Yes, Your Honor. Yes, my name is Nicole Malenko Neely, and I have been a private assigned counsel in Mecklenburg for the past 16 years or so. And I believe in the presentation, I believe Aaron Gallagher said he received 2 other notices from attorneys in Mecklenburg County who said that they were leaving the list. I'm thinking I may be one of them. I'm on a temporary hold. I can still go back. But I appreciate, so I've been here for the entire presentation about your ideas, what you're all trying to do. And I love your ideas. I love your troubleshooting each aspect, but I do have some questions about the payment process based on the presentation. So I know one of the issues was judges not signing fee apps in a timely manner. Drawers full of this, or I'm wondering, does IDS have the power to require judges in each county to sign off on fee apps after so many days? Do you have the power to pass? I've heard in the beginning, you were saying second, all in favor, aye. Do you have the power to do that, to require the local judges to establish a plan where the judges in each district will be required to sign fee apps off in so many days?
I don't think we have the power to do that, but what this proposed plan includes in it is the fact that you all, as a private assigned counsel, will actually be paid and not have to wait for the judge's signature in order for you to be paid. So that should help in that regard.
I listened to that part, but it's also my understanding that this project, the Oasis, will not be implemented until 2025.
Not fully, but.
Not fully, but you're in an Odyssey County, so it would roll out probably sooner than anywhere in Mecklenburg.
Well, I am in an Odyssey County.
Yeah.
Yes.
So Dorothy, I
when-
think in response to Nicole's question on the judges,
Yes.
you know, the commission could consider, I don't know that you want to do this today, saying that if the judge hasn't signed in X amount of time, any objection is waived, and we, you know, but I don't know that that's something, since we're paying, if the problem we're trying to resolve is that the judges are holding on to these fiats for a long time, that is eliminated with this system. So, all right, I'm sorry, Nicole.
Excuse me? Limited?
I'm sorry, I didn't hear what you were saying, Ms. Neely.
Yes, and I'm sorry, I don't know your name, ma'am. So, Chad Boykin's room wearing the red suit.
That's
Would
our
you please
executive
repeat what you said?
director, Mary Pollard.
I'm Mary Pollard, and that's Dorothy Mitchell. Our
You're
Judge
Mary
Mitchell is
Pollard.
Richard.
Okay,
Yes.
I only know you via email. Thank you, Director Mary Pollard. So, would you please repeat what you just said regarding just the last sentence?
About how it is a problem when judges delay signature on fiat, but with this system, we would be paying you before the judge signed. And then we would just, if the judge cut the fiat later, we would come back and say, hey, Nicole, can you send us back the $10 or whatever? But it happens so rarely. It happens so rarely. Yeah.
Okay, so, but in the meantime, in my county, as far as if my colleagues and I want to get up with our judges and say, would you please make sure, you know, that you could sign timely? Who else would you suggest that we include on our meetings with our judges?
So
With
I
our
think
superior,
I think that you
superior
should
district court judges.
probably your chief district court judge, your resident chief superior court judge, and any other folks that have the ability to issue administrative orders and deal with the local rules in your district would be the folks that I would suggest. And I can tell you, Ms. Neely, having been a PAC attorney, having also been an assistant public defender, and especially a PAC attorney waiting on fee apps to be paid, and then now as a judge, I can tell you from my experience that I don't know of any judges that are just sitting on fee apps with the intent to harm you all. We want you all to get paid. That's not the intent at all. And so I don't want that to be the notion that you leave away with, okay?
And yes, well, thank you. But in our county, we've had to start going to different judges to get stamp signed. Particular judges were not signing. That's why I asked this question. And
yes,
I
ma'am.
appreciate you. And I also
that I gave you would probably be a good folks to start with in trying to urge the judges there in those areas.
I can do it, and I will. I can at least do my
Good
best.
luck to you on that, Miss Neely. Mary, did you
I
have
have a
something
second
else?
question.
Oh, I'm sorry.
Yes, no worries. So you all said that, you know, the PAC were the backbone. And I know you know, the situation is grave. And so also in light of that, there are only 5 employees who are processing in your department. I was wondering if you all have ever considered hiring an additional 1 or 2 employees to handle the backlog, since this is a crisis and you're concerned with losing the backbone.
So I can take that. We have gotten a temp funded through the Administrative Office of the Courts. We are funding 2 additional temps through an IDS lapsed salary. We do not have the authority to create positions here without explicit legislative approval. So we're doing the best we can. We are asking, and in fact, after this portion of the meeting, I'm going to be talking about the legislative agenda for the short session. And one of the things that we're asking for is more bodies to help us with this crisis. So we are doing the best we can to catch up. You know, the alternative to going to this sort of web-based fiat system would be to hire, I think we've estimated 6 full-time staff to get us back to where we can pay to between 30 and 45 days from receipt. But of course, that doesn't eliminate the front end delays. And one of the nice things about this system is it eliminates the front end delays and the back end delays. I wanted to follow up on.
Yes.
I wanted to follow up on your question about trying to get things to work better in your county. And I agree with Judge Mitchell about, talking with the bench. I think it's also really important to talk with the clerk of court and make sure that the folks there who are using e-courts, it's new there, that they are understanding how to get that signed fiat from wherever it is into the IDS task queue, because there is some kind of a breakdown there. It seems to be worse in certain case types, and it's very opaque to us. But I think maybe bringing that to the clerk's attention as well, and we have, so, but they need to hear from you. They know you're their constituency, right? So,
Yes.
And I think you had
So
another question.
I appreciate you. Thank you very much. And I will do those suggested things. And I also want to say that, in speaking with Aaron Gallagher, when he was out on medical, he's been nothing but helpful. And I understand that his staff has been working very hard, and so has Mr. Gallagher. And I appreciate him and his staff, and I thank him.
Thank you.
All right. Thank you, Ms. Neely, for those words and for your service as a PAC attorney with us. Ms. Franco, did you still have something?
No, actually, Miss Neely asked the question that I was going to ask, if there was a time limit on the signature for the judges.
All right.
Thank you.
Thank you. I don't see any other hands up. So I think, oh, okay. Mr. Doyle.
Thank you very much. Why do we have to put on these fiats time waiting in court?
Chris Sadler.
So we do it for a variety of reasons. One of it is like if solely research, knowing how attorneys are spending their time. If you're waiting in court, presumably not doing attorney work, and we do have issues with controlling the calendar, moving things along. This data point helps build an argument to speed up the process, so to speak. I understand that it's frustrating, but one of the other things it helps with from, say, an audit standpoint or a financial standpoint is, and this is one of the issues that we had with attorney billing. It was a very easy way to catch fraudulent billing based on fiat days, because you're supposed to prorate your time waiting in court. So if you're sitting there for, say, 5 hours, which does happen, go back to the part about using the data to help make an argument for maybe more control over the calendar, some of the other things. But you're supposed to prorate that 5 hours over, say, your 5 cases, not bill 5 hours waiting for each of those cases. That's how we were able to discover folks billing for more than 24 hours in a day. Sometimes it's accidental, or most of the time there's accidents around it, but sometimes take that with structured invoicing and some other things.
I mean, it's crazy to pay me for waiting. I've always, in my 42 years, have urged DAs to put a little sticker on that shuck that client is court appointed. And let's move that case up to the top of your stack. I should not be behind a guy who's getting $200 an hour to negotiate with a DA over a DWI when I've got a simple misdemeanor I could knock out in a second. Right. I don't know if the Conference of DAs would be willing to consider this, but that's a problem. If it's court appointed, then everybody in the courtroom should be thinking, how can we move that case faster? The clerk, the judge, even the bailiff, because that's saving taxpayer money. And again, now the way district court works, you've got boxes and stacks. failures to appear, pro se, attorney box. I invented the box in Orange, actually. I never get credit for that. Anyway, let's have a court-appointed box. Make it red or Carolina blue. And that way, all the people in the courtroom know, let's get George out of here.
Yeah, I think everybody here would agrees with that statement.
Definitely. We appreciate that, Mr. Doyle.
Thank you. Please call me George.
Yes, George. All right. So I want to remind everyone two things. One, I think you all talked about us having a marketing sheet that's going to be sent out, so folks will be adequately informed about all of this as it rolls out, if we approve this rollout. So that segues into my next step, which is I think that what we have before us, and that please you all correct me, Mary and Chad, if this is you all are asking for us to take action and approve the rollout proposal that you all have presented here today in regards to this system.
Yes, Madam
That's
Chair.
correct.
All right.
We approve the rollout.
Awesome. Thank you, Staples. You got right where I was trying to get to. Do I have a second on that motion?
Second.
Have a motion and proper second for us to approve this rollout proposal that was presented today. All those in favor, please say aye.
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 Any opposed? Nay? Or thumbs down? I don't see any. All right. So approved. Thank you all. We know that you all are going to do everything that you can and do a great job like you've always done and keep us informed along the way. And like I said, get the information out to folks so they'll know what to look for and be educated properly on how to utilize this system correctly. All right. So I think this will be a good place to take a little short break. And then we will come back and go into our IDS business. Well, the report from Mary, starting with you, Mary. Is that okay?
That sounds great, Dorothy.
All right. So can we, with 5 minutes, be okay?
Thank you. Thank you, everyone. Thank you so much. Thank you.
All righty.
That I'm told.
I'm ready. I'm gonna go up to the podium because I think that's the easiest place.
Okay.
For you all to hear me.
Chris took his laptop, so we want to
So
put
as Mary is coming up, we are going to go back on our agenda to director's report on IDS.
You're good. You're good from there.
I'm good from there. Okay, good. Okay. All right. So I know that was a lot. First, I want to thank Chris and Chad and Aaron and Jamie and everybody, Shannon and our AP staff and everybody who has been involved in brainstorming and developing what you have just heard. It's been a massive amount of work on top of a massive amount of work. And I'm just really so proud that we have a staff that's capable of doing this. Yeah, because they were all hired for different reasons, right? But we're gonna fix this problem together, so thank you all. My report on IDS business. Okay, the first item I wanna talk about our IDS's legislative agenda for the short session. As you all know, we're coming off a long session where we got 8 new PD offices and had a lot of success there. The short session is just that, a short session. It is not a time where we're going to be able to get a whole lot of money or enact ambitious things, but we are going to make some budget expansion requests to bolster some of our needs. And we've met internally in the central office and we've touched base with the state defenders and we've put together what we think is a reasonable request for the expansion request for the short session. First, we're going to in the long session in 2025, right, we're all going to band together and launch a campaign to get PAC rates raised. But in the short session, we're just going to ask for $1 million to ensure the long-term solvency of the PAC. You know, you heard some concerns at the October meeting about how the PD expansion was funded by an immediate reduction in the PAC instead of a phased reduction in the PAC. So we want to make sure we have enough money to to be insured, to be solvent through 2026 and beyond. So we'll be asking for a few $1 million in non-recurring funds to plug that hole. We are asking for some amount of money. I think the number I saw was $300,000 to fund some technology and hardware things that we know that we need, that we didn't used to know that we need because of the eCourts expansion. For example, we have to buy something called a NAS drive for all of the PD offices to store discovery. It's a device, it's expensive. So we're asking for some money for those hardware needs. We are asking for some additional central office positions that are currently receipt funded through the PAC fund to be an appropriations funded. These are fiscal staff positions. We need them to help us get through the fiat crisis. We're asking for a position in the parent defender's office to be moved from receipt support to help us expand the MAC program and work with parent attorneys on FIAPs. Because as you know, as the program we just explained is just for adult criminal for a variety of reasons related to confidentiality of those records. We can't do it for parent defense cases and juvenile cases. And we are asking for some desperately needed positions that we have asked for before in the Capital Defender's Office, in the Appellate Defender's Office, and in the Office of Special Counsel. So we will circulate sort of a draft of that ask once it's permanent. I'm not entirely sure when it's due. We put something together for the Office of State Budget Management, which is the first step in the process. So that's the legislative agenda. I want to talk about the 2023 IDS audit report, and I am pleased, although not surprised, to be able to report that we got the results of our annual audit and that IDS was given the highest rating of effective. As I understand it, though, we passed all of the tests that the auditors gave us with the equivalent of what would be an A+ on a 100-point grading scale. And that's really impressive. Thank you to everybody who touches FIAPs and money. It's really, really important, right? I think when we go to the General Assembly to ask for money, we have to show that we're responsible stewards with oversight of the money that they are already giving us. So this is a really fundamental bedrock thing. And we couldn't come close to fulfilling our mission as an agency without this sort of performance by our fiscal folks. So thank you and congratulations. The last item is the IDS and State Defender relocation update. At the last commission meeting, we reported that we would be pursuing lease negotiations for space in the Parkline building for the state defenders. I need to report today that we are not going to pursue that move at this time. This was a difficult decision that was made for only after careful consideration and for the following reasons. Primary reason, a review of our operating budget post PD expansion, it is tighter than it should be. The General Assembly did give us a small amount of additional money for moving, for increased rent, but it's not sufficient. And while we could maybe make it work in the short run, it was not going to work in the long run without more funding, and I have no interest in leaving my eventual successor with that sort of problem. We will go back, we will ask for the money we need, and we will continue to pursue a move because we can't stay where we are for the reasons that you all know. Second, the landlord's initial lease proposal, which kind of coincided with the time we were reviewing operating expenses, included a number of provisions that they had been informed were not acceptable for state government. And it also anticipated that IDS would take on a role in upfitting that had not been earlier communicated to us. It is possible that we could have negotiated back to where we needed to be, but the hardball approach they took in a very soft real estate market was a red flag and problematic to me. We've learned from self-help that contrary to what was represented to Will and me, the building is not being sold at this time. They're going to allow us to extend for some period of time. The building is deficient in a number of respects. I imagine they will sell it at some point. If they kick us out, we have to find new space. Well, then, you know, we'll do what we have to do. And so but we do need to continue to work on finding a suitable location and obtaining funding for that. I do appreciate the time that was devoted by Will and by everybody on the rehoming committee, and that time was not in any sense wasted. We know our needs. We have commission guidance about the type of facility we need, location of facilities. We will be able to secure realistic funding that will allow us to provide decent office space for our staff and move, I hope, in late 2025 or early 2026. I think taking a pause on this effort is also allow us to get more clarity about the future of the real estate market. The vacancy rate in the Triangle is extraordinarily high right now, north of 20%, and the rents are coming down. That's got to change at some point, right? I'm not in any hurry to enter into a 15-year lease until there's a little bit more certainty there about where things are going. We'll also have a better idea about our true space footprint needs post-pandemic, and we will also be past, I hope, some of the crises we're dealing with right now, and we will have more human resources to devote to moving, because it would be an awful strain on the staff to try to do it over the next 6 months. So we're just going to take a pause, and we're still going to do it, but we're going to do it slow. We're going to get it right. So we are continuing to, this is important. We have temp labor. We are continuing on the document scanning and shredding project, and otherwise preparing to do the move, because that work needs to be done, and that will be done. So, and I think that is my report. Are there any questions?
Thank you for that report, Mary, and all those wonderful things, and especially the excellent rating and the audit and all of those good things. And your report is always robust. And Mary, I want to tell you that we appreciate and trust your judgment in regards to this rehoming. I think that our rehoming committee made it very, very clear to you that we trust your judgment in this regard. And so we received that. We may have some questions about it, but I would like to start off by at least saying, would you please communicate to the staff, as I know you probably have already from yourself, but communicate from us as the commission, that we understand the need for you all to have safe and comfortable, reliable space to work in, and that is important to us, and that's what our goal was when we had this committee formed, and we were working towards them getting some better space. But that's always at the top of our list, always high importance to us, and we would do everything in the interim that we can to make sure that the space is all of that in what we are working with right now. And yes. Like I said, I know you've communicated that before. If you could communicate that from us, because we certainly had in mind the perks that they would receive, and you all would receive.
Yeah, we're gonna get there. We're gonna get there. And in the short term, we are going to be able to make some inroads, I think, with our current landlord. Like, we have 2 elevators working right now. We've had we've had heat all winter. Things are
wonderful.
Yeah. I think they're maybe going to do some painting and carpeting, and we'll see. But thank you for those words.
For sure, we definitely want to be fiscally responsible, and that is what it sounds like we're doing in the way that you're going about it. So we appreciate that. Does anybody have any questions of Mary, Mr. George?
Thank you.
Yes, sir.
Mary, since I met with you and your wonderful assistant, I noticed in district court that when you break down the costs of court, there's a thing called indigent defense fee pursuant to a chapter in chapter 7A of $5. I was wondering whether it would be easy for the legislature, because of their commitment to you all, to raise that from $5 to $6. I know it's a very simplistic approach, but I just noticed that, and I want to be informed about what's going on here. So I'm asking you about that.
Thank you. I wish that Will were here. He may be online. He wasn't feeling well earlier, but I believe that fee was raised in the 2021 budget, or maybe even the 2019, and that's part of where we got the funds for the last fee out. There's a fund
redirected. I don't
Or
think
if
it was
it's
raised, but it
redirected.
was redirected
Okay.
to us.
It was
fully.
redirected to us fully, yes. Yeah, so that is one way they could choose to give us more money, right? And I think there's a philosophy about whether it should be an appropriation or related to court fees on the users or some balance there too. But we got that $5 fee. We didn't get that before I went to somebody else. We got the $75 appointment fee. Then we get some money through recoupment. You'll hear a little bit more about that. Are you doing that later? Yeah. And then we get a general appropriation. So we would like them to give us more money. Yes.
Certainly, always. Any other questions or comments in regards to Mary's report? All right, thank you so much, Mary. So I think now we're back down to staff reports. And we'll move to Eric. We always have wonderful reports from Eric, our juvenile felony murder project.
Thanks, Judge. I
Yes,
appreciate it. So I just wanted to give you all an update, specifically on roster applications. So they've been open for about 4 months, since early October. As of this week, we've got 33 applicants. We've already approved close to half of them. We just haven't notified another half dozen that they're going to be approved. And more or less, the rest of the applicants would be approved after they participate in some training or some court observation. Our goal right now for the state is 50 attorneys to be on the roster. So we're not that far away. I think the process is rolling along. We've made a couple of adjustments to make it easier, especially for those attorneys who are currently on the capital roster. Now they can skip some steps.
What happened? Eric,
I think you went out for a second. Uh-oh. Eric is steady talking.
He does not show as muted.
Eric, I don't think he can hear me either. Eric, we can't hear you.
I texted him.
Can't hear you. Okay. Yeah, it doesn't show that you're muted, so I'm not sure.
Yep. Eric, you should check your output on your state issued machine.
Okay, how about now?
Yes, we got you.
Okay, I'm sorry. Something was going wrong with my Bluetooth. All right, let me start over.
Yes, please.
All right, the roster has been for 4 months. We've had about 33 applicants. About half have been already approved. Most of those who are pending approval either just have to go to a training or maybe have to have some other small piece to make them eligible. Our goal is to have 50 attorneys to cover the state. So we're getting closer. We've made some adjustments to the application. So those who are already approved for the Capital Defender roster now can skip some steps. We've also talked to the State Bar Board of CLE to make it easier for folks to get their past list of trainings completed to us. Because some of these attorneys, for example, who've done a lot of adult criminal work, maybe have not done any juvenile. So we're just recommending that maybe they do a quick online training to get acclimated to the juvenile process on the front end. The number of attorneys, the number 50 we're getting because we've seen now data from the past 3 years. And for those counties participating in the program, it's somewhere between 80 and 90 youth being charged annually. So we figure if we have 50 lawyers, that'll probably do it. So they'll take 1 to 2 cases a year, maybe. You know, we just continue to reach out in different ways. We're still soliciting with the lawyers on our mail merge, on listservs. We've reached out to judges to try to get some suggestions from them. So I'm actually right now at the North Carolina State Bar building because I'm splitting time with the North Carolina Leaf Board. But Michael Waters, who's district attorney, I forgot what the new district number is. I think it's 10, but you know, Franklin, Warrenton, that area. He solicited a couple of names to send to us, and I thought that was great. I think this will work better the more, you know, individuals can get the word out to folks that this is happening. And all they have to do is go to ncjuvenile-defender.com, and there's a link that says juvenile first degree murder roster, and they click on that and all the information is there. But of course, as always, anybody can reach out to me directly or anybody in the office to get any more information about applying. So that's really the update. As usual, I want to thank the IDS staff. They've also been helping us work through payment issues. A lot of what you just heard, you know, we're hoping we're going to go through the same system that the MAC attorneys are going to go through. We've been working to figure out the payment of experts. So we're just waiting to get that sort of, mass number of attorneys. The only other thing I would say is that we're going to review this in a couple of months. And if we think that we have enough attorneys maybe for one area of the state, we might try to do a limited version of appointment. And I'm going to talk to my juvenile committee about that this month. But I'm fairly hopeful we'll get the number of attorneys we need fairly soon. So I'm encouraged since the start of the year that more have been applying. So hopefully we'll get there soon. And I'll be glad to answer any questions.
Thank you, Eric. Any questions from anybody? Sounds good that's rolling along well, Eric.
Well, thanks everyone. And again, tell your friends and neighbors who are interested, please apply. We'd be glad to take a look at them.
As in office neighbors, not your neighbors.
Well, you never know.
Right. All right.
Thanks, everyone.
Yes, sir. Thank you. All right. So we now moving right along to other commission business. IDS rules and policies. We already did that one. I'm sorry. My apologies. Oh, we're rounding out. We don't have anything else, Mary?
We have a staff report, Dorothy, on set off debt.
Okay, yes. All right. I didn't see that one. So yes, if we can have that report and then we'll go back to the committee assignments.
Is that okay, Mary?
Yeah.
Thank you. Thank you, Madam Chair. I am sorry that everyone is subjected to me a second time today. I'm going to try to make this quick. In a few of the discussions we've had earlier, we mentioned set off debt and recoupment. I have a quick report for the commission on the status of, I believe, 3 issues related to set off debt and recoupment to report for you today. So as a quick refresher for people who are unfamiliar, under 105A3, state agencies like ours are required to participate in set off debt. What happens is our indigent clients, if they are convicted, may be required to repay the state the attorney fees with expenses at 8% interest under 24-1 and that appointment fee, which is currently $75 that we were just speaking of a moment ago. All of that is subject to recoupment. Recoupment is enforced in 2 ways. Either there is an order to pay as a condition of probation, or the amount is docketed as a, as a civil judgment. And that is enforced through the North Carolina Department of Revenue intercepts of both North Carolina state tax refunds or lottery winnings. And the North Carolina Education Lottery, that's what NCEL is there. That's an unfortunate acronym, but it does mean North Carolina Education Lottery. So here's our recoupment revenues. Every year we receive about $10 million in total PAC funding through recoupment. That translates to roughly 1 month of tax spending. And usually what happens is this averages to about 5 million through probation and the other 5 million through the civil judgment and intercept process. How this process works is that AOC sends data files to the Department of Revenue, that's DOR. These files contain the total amount owed for the principal debt, the interest, and the appointment fee. Department of Revenue intercepts up to the total amount reported. Unfortunately, I have to report that the data files that are being sent by AOC through e-courts to the Department of Revenue are incorrect. Our research division has found that the principal debt is not being sent by AOC to DOR in the e-courts counties. Only the appointment fee of $75 and any accrued interest is actually being sent. This is especially dire for new judgments. And when I say new judgments, I mean those that have been docketed post e-courts. The reason for that is because e-courts currently cannot automatically calculate interest. Thus, no interest is being calculated on new judgments, and the result of that is that only the appointment fee of $75 is being sent on new judgments in the e-courts counties. This is a chart that summarizes a sample. So the highlighted columns are the interest amount and the appointment fee amounts, and only those amounts are actually being sent to DOR. In just this small sample, you can see that the total that should have been reported to DOR out of this small sample was $3,639.40. What was actually reported to the Department of Revenue was $1,606.57. The amount that was not reported and was not recouped is $2,032.83, which is the majority of the debt in this sample. In each of these cases, the full amount that was reported to the Department of Revenue was fully intercepted. What that means is that there was probably money left on the table. There have been over 3,400 intercepts in the e-courts counties. The number of e-courts counties is going to more than triple this month, and we are at the beginning of tax season, which is when most of our revenues through state tax intercepts actually happen. IDS sent a memo to AOC with these findings on January 19. We were informed that a fee code could be added that would include those principal debt amounts to the Department of Revenue files. We sent a follow-up request on January 26, and to date, we have not been provided with a firm timeline for when this will be fixed. We will continue to follow up and update the commission as soon as we can. As previously reported to the commission, unlike the legacy system it replaced, eCourts does not contain an automated means to operate set-off debt. Our research director, Chris Sadler, has custom programmed a basic means for us to continue operations while awaiting a module for eCourts to do that job. We have been using that since the Odyssey rollout that started in February of last year. One drawback with our in-house solution is that until there is automation, all the intercepts that we take in the eCourts counties have to be reported to each clerk's office, and those clerks have to have staff manually apply the intercepts and the funds taken to the judgments. In some cases, there are multiple judgments that go across multiple counties. So there's a multi-state spreadsheet for those, and if the judgments are limited to one eCourts county, they get those judgments on that spreadsheet. It is a laborious process. It is time consuming. The original 4 eCourts pilot counties were provided a list of intercepts and judgments that was created by IDS for them in August of 2023. Every county except for one has to date applied all the intercepted funds to the judgments. If all funds are not applied by tax time, there is an increased risk of duplicative intercepts wrongfully taken because of the failure to apply the funds intercepted last year to the judgments before the intercepts start happening again at tax time. Those intercepts would have to be refunded by IDS with interest and with the $5 Department of Revenue fee, which means it would be a net loss for IDS since the refund we make is greater than the amount we intercepted in the first place. So that's the risk to our budget. The importance of automation for the application of intercepts to the judgments is a critical part of this process. Right now, we're still having to do it manually. We're doing what we can do to make sure that we keep these funds coming in to operate our PAC, but this is the issue, one of the issues that we're facing. The risk to IDS and to the taxpayers grows exponentially as eCourts expands this year and clerks have to continue to manually apply intercepts to judgments. Again, 5 counties have been having to do that. It's about to be 17. And it is almost tax time. There is to date no ETA, no estimated time of arrival on automation. A module we have been told has been in testing for several months, but we don't have any firm details on the results of the testing, how long it's expected to take, or what the functionality is to date. And I know that that's not good news to hear, but we do need you to understand what's happening because this does affect our budget, particularly our PAC fund. I have one more issue, a final issue to report, and that is that all civil judgments for attorney fees in eCourts have to be manually flagged by the clerks as eligible for set-off debt. The acronym there is ESOD, but they have to be manually flagged one at a time in order for that judgment to be sent to the Department of Revenue for intercept. Reports demonstrate that this flag is not usually being applied. This means that debts in eCourts that should be on the files that are sent to Department of Revenue for intercept are not being sent because they are not being flagged. This chart shows the historical average number of civil judgments for attorney fees docketed per month in the original eCourts pilot counties. We get this data from our set-off debt team who give us, this is what we expect on a monthly basis from these counties as far as the number of civil judgments that are eligible for set-off debt. The largest county in this chart of the original 4 pilot counties is Wake. As an example, Wake generally docketed 800 to 1,000 cases per month for our set-off debt team. The reports that we received for the first 7 months of eCourts were generated. At the time of this study, we would have expected 5,000 to 7,000 ESOD cases to have come through in Wake County in eCourts. However, there were only 768 total. We would have expected about 2,800 in Johnston County, and there were only 20. Internal Audit performed an assessment recently and found that in one county of 24 judgment for attorneys fees in one of those eCourts counties, only 2 of those were properly flagged as eligible for set-off debt, meaning 22 of the 24 cases were not sent to the Department of Revenue for collection. This non-compliance with the set-off debt statutes was reported to AOC in October of 2023. AOC is producing a means to modify new cases in bulk so that the clerks can do this in one fell swoop. However, the ETA on that is not known. We have followed up. We don't have any more up-to-date information on the estimated time of arrival for that. AOC has asked IDS in their response to learning this information, they have asked IDS to provide the clerks a list of the thousands of cases that need the ESOD flag so that the clerks could review them and decide whether or not to add them. That's going to take some mechanisms in the eCourt system that we are working with external partners to get because we do not have access to those tools. But that is what we are working on so that we can provide that for the clerks. So essentially, most of the cases that are recoupment eligible are not being sent to the Department of Revenue. Of those that are, only the appointment fee and the interest is actually being sent. And I really wish I had a better report for you, but this is something we felt you needed to know. And if you have any questions, feel free to share those now. And I wish I had a better report for you on this. And again, this is affecting eCourts counties only. The legacy systems, to the best of our knowledge, are still operating because there is a functioning automation in the legacy counties. And we are again rolling out to another 12 counties this month. So this problem is getting bigger and we are very eager for a set-off debt module that will allow automation to correct these problems.
All right, thank you for that report. Does anybody have any questions in regards to
this? Is Staples. It seems to me that this is a matter that the General Assembly needs to be aware of. I'm assuming that in the upcoming short session, there's going to be some complaining about eCourts generally, but this specifically has to do with financing the indigent defense system, and they need to know.
Right.
I think we'll mention it in our annual report to the legislature, which is due in March, and we'll certainly have discussions with individual legislators about it. I think the most recent iteration of the automated module was delivered on January 29th. We don't really have a report on the testing status. Obviously, we're concerned as to how this affects our revenues. There's a handful of other issues that concern us that are connected to the rollout of e-courts. One is that for privacy reasons, they took the social security number off the affidavit of indigency, which is, of course, used to be the first best opportunity for us to get that number. That's probably going to affect our recoupment. The other that we're kind of keeping an eye on, and I don't know, maybe this will get better over time, but people who have district court practices are telling me how much longer it's taking to resolve a case. And as we all know, time is money. So I don't know what, if any, effect it will have on the PAC fund over the long term. I mean, I expect as people get used to the system, things will recover. I don't know. Yeah.
All right. Thank you, Mary. Anybody else have any questions or comments? Is that all you had, Chad, in regards to IDS rules and policies? That was it?
Yes, Madam Chair.
Okay. All right. So moving right along to other business. So commissioners, you all should have received in your commissioner materials that were emailed out one memo in regards to some changes that we are looking to make with our IDS commission committees, as well as the list and proposed committee assignments, particularly the ones from last year, and then we're looking at making some changes. But I will pass it off to Mary to speak a little bit more about some changes that we would like to make in regards to our committees, and definitely want to encourage you all to be ready to serve on these various committees. We have quite a few that we would ask for you all to let us know if you're interested in serving on those committees. We have kind of looked at the makeup of our commission and went through all of our folks and your expertise and background and looked at what committees we think will be best for you to serve on. But we certainly like to hear from you all if there's one or some in particular that you would just absolutely like to serve on. But then at the end of all of this, once you let us know, Mary is going to give a little bit more, like I said, on the changes in the committees. And then after today, you will get an email from Whitney in regards to the actual committee assignments, because ultimately it's the chair who needs to make those committee assignments. But I certainly want you all's feedback and your interest if you have some particular interest. So with that being said, Mary, I'll pass it over to you and let you speak more to those committee changes.
Sure, I'm not sure. So I think the big change, Dorothy, is that we're going to work some of the committees that haven't had a workout over the past couple of years a little bit harder. The committee that we have called Strategic Planning External is basically going to be the committee that is going to follow through on Becky Whitaker's presentation from October about the workload recommendations. And there's a number of you who I have great interest in and hope you will serve on that committee. And I will reach out to you shortly if I haven't already. And Becky Whitaker is also working on getting that committee staffed with some ex officio members and representatives from the public defenders to get those workload recommendations done. The other committee that we're going to work a little harder than has been done historically is the Strategic Planning Internal Committee, and that is going to be morphed into the, and this is, thank you, Miriam Thompson, for this suggestion, basically the Technology Committee to look at digital discovery, how technology is affecting the life of our public defenders and our PAC, make recommendations about best practices and best types of software and best types of tools, right? We, and Becky and Chad could talk about this at some length, but we get bombarded with requests from vendors and everybody has the new best thing for use in transcriptions or in this or in that. And what we need to do is come up with a package of what's best and what we can afford and work to make that available to everybody. So technology and workload are going to be our two big projects for the next 12 months. Review the committees and let us know, me or Whitney, where you want to serve, and we'll slot you in. So thank you.
Did we in fact get any kind of memo about current or proposed committees? I did not see one in the materials. Maybe I just missed it.
It was in the supplemental materials, Staples, the current assignments, which means Commissioner Doyle and I think perhaps even Commissioner Ellis don't appear on it. And
Right.
then kind of a brief thumbnail of the general direction Mary wants to move the strategic planning external and the defunct strategic planning internal in over the coming months. I will follow up with all of you late next week with a reminder to consider which committees you think you would be most valuable on or would enjoy serving on the most, and then probably round up with Dorothy and Mary and assist Dorothy in making her assignments and letting the commissioners know what those assignments will be.
Absolutely.
Did others get that in their packet and I just missed it?
So it was a supplemental packet that came
5 a.m. this morning.
Yeah.
Well, we'll send that by email. We can just carve that chunk out and send it around by way of reminder. Is that fair, Whitney?
That's, if I can remember to attach it, it's perfectly fair.
You know, in some of the committees, we always need a review committee, although we haven't had opportunity to meet in a while, but right, that's an important committee when people are asking to reconsideration of roster decisions. Appointments committee, we've got a bunch of commissioners rolling off later this year, and that might be a more active committee than it has been in the past as we try to make sure that all the appointing authorities timely get us new commissioners. All right, thank you.
Absolutely. Thank you, Mary and Whitney, for your assistance in that as always. And thank you, commissioners and our other folks who are not commissioners, but maybe sought to serve on a committee for your prior work and for your future work. And especially in fact, in regards to us having to do a little bit more on some of the committees. We really appreciate your service in that regard. So finally, we are at the place. We have one other matter that we may, I want to ask the commissioners, did you all receive an email from Whitney you should have received an email from Whitney with a memo a confidential memo, in regards to some litigation. And so I wanted to see, can I get from you? Okay. So hopefully you all have read that. If you have not, I want to give folks an opportunity. Okay, great. I see you, Brian. Thank you for that. Give you an opportunity to review that. And what we would like to do is see if anybody has any questions. There are some questions that we can certainly address here. If not, we may need to go into executive session. And if I'm not mistaken, if not, then that we won't need to on any other matter.
Commissioner, I did not receive any email from Whitney, so if that could be resent or shared somehow.
Right. So Whitney, can you send that email to Stacy? Because we can't share it, Stacy, because it's a confidential memo in regards to that. So we can't share here on the screen, but if you could just resend it out to everybody, Whitney, just to be sure. I know some folks did get it already, but just to be sure everybody got it.
Stacy at fd.org.
Stacy_Rubain at fd.org.
You may want to check. It was sent at 9:20 this morning, or maybe 9:18 this morning. So
Yeah, no, I've not gotten anything. I didn't get the other email either that Staples referenced, so.
I'm afraid that the other email may have cached to QR.
I do too. I think so.
I need to remove that from my cache.
We'll get you set up though.
With pretty easily is This is another piece of litigation that's been filed pursuant to the State Torts Claim Act in the Industrial Commission. The plaintiff's name is Belinda Brown. You've received prior updates on this case because it has been pending since around November 2019. We're on our 4th Assistant Attorney General, and because of COVID and other reasons, it's lingered for a long time. There was a contested hearing in Fayetteville on Tuesday, January 29th, where the deputy commissioner basically examined the pro se plaintiff Belinda Brown, and then RAG examined Cindy Black, the chief public defender for Cumberland County, and Amanda Briggs, the assistant public defender. Ms. Brown is alleging that Amanda Briggs failed to secure her appropriate jail credit, and that as a result of failing to get that jail credit, she incurred substantial damages. The facts and the law in effect at the time of the sentencing are established pretty well that Ms. Brown received all jail credit to which she was due for her sentence in Cumberland County. And I think that our Assistant Attorney General did a decent job working with Chief Black and Assistant Briggs in establishing or laying out for the commissioner, who does not have any familiarity with North Carolina criminal law, kind of what the right calculus was and what the actual answer should be to the question of how much credit should Ms. Brown get.
That was a good synopsis. Anybody have any questions in regards to that? There's no action or anything that we need to take right now.
I'm not recommending any action, and I think I can say that in open session too. That's the other thing I can say. Unfortunately, this is not going away. It'll be 45 days before we get a transcript. I'm sorry, it will be up to 2 months before we get a transcript of the hearing. That starts one 45-day deadline. Once it passes, another 45-day deadline, and then the commissioner feels pretty confident that he could get a ruling out in about 90 days. So it may be the late summer meeting before I have anything significant to provide you guys with.
All right. Any questions? Comments? All right. So I think that has gotten us through our entire agenda. I'm looking to see if okay, Mary's not giving me any cue or anything. All right. Yes, thank you, Mary. So, yes.
I just wanted to,
I thought that was a hands up as in
no, there's no more agenda. I just wanted to thank the commission, everybody for coming out today and listening. I know this was a lot, but it was kind of a significant presentation for our folks to make, and I'm glad you were all able to be here and consider it and give us feedback. So thank you.
Absolutely. You are welcome. We appreciate all the hard work that's been put into everything as always. And I want to end by thanking all of you all for attending this meeting. I know sometimes it can be really, really tough to actually have a meeting online via WebEx or Zoom or whichever platform you use, but we have gotten through it and in less than the time that we usually get through it. And so good meeting in that regard. As well, it was a phenomenal meeting in the fact that we got to meet our new chief public defenders, and we look forward to meeting you all in person when we meet in person again and or otherwise. We so appreciate you all for joining us in this regard. And like I said, any meetings and all meetings that you can attend, we look forward to seeing you. And this is kind of how we flow normally, whether it's online or in person. So if you have any questions, continue to shoot those to Mary and her staff. And you can also certainly reach out to me or any of our other commissioners as you see fit going forward. So thank you, everybody. I don't think we need a motion to adjourn since we got through our entire agenda today. So we appreciate you all. I hope y'all have a good lunch and the rest of your day. And until we meet again.
Commissioner, I hate to interrupt you, but I have to say, I appreciated your presentation to the whole day, and you could be a newscaster or someone on TV. You are awesome.
I appreciate
thank you again.
Thank you. Take care.
Take care.
All right. Y'all have a